I may be pardoned to make a mention. Pardon to make a mention. No?
Good president. Chanting Lord Jagannath.
After all, we are all his children.
And Salvation is lost. And Nalu Tishtami Vaikunthe Joginam Hrodaya Nacha Mat Bhakta Jatra Gayanti Tatra Tishtami Narada. The court hall itself we attempted.
That's true.
I may be pardoned to make a mention, Lord, because of the urgency involved. A plot was allotted to the petitioner by the Bhubaneswar Development Authority in the year 2022 and staying there with the construction of the building. Now, in the year 2025, the allotment has been cancelled on the ground of multiple allotments.
When it was?
20. That is on
Tell me the other.
29/7/2025.
29/7.
7th. I filed in the second week of August.
Tomorrow we'll have.
Yes.
Real urgent matters I will take. But don't make special urgent.
Thank you, sir.
Yeah.
Pardon to make a mention, my lord. Here in this case, the petitioner transfer 1 crore rupees to a company, inadvertently sent to that company, send another company. Subsequently, that company bona fidely disowned that money and write a letter to the bank. And writ petition was filed and the bank appeared and that writ petition is disposed of and allowed. Bank itself says that there is no claim of there. And subsequently, the bank filed an interim application. My lord, the money is still lying on the bank.
Lying in the bank immediately after vacation.
Any date may be fixed in after vacation.
This is identical matter. This is identical matter. Similar matter listed today, matter. One matter left out.
One is left out.
Petitioner is the teacher 12 dismissed in service.
Dismissed from service.
Yes, sir.
Immediately after vacation we'll have that. That dismissal happened long back, no? Yeah.
My lord,
Item 6.
this matter was supposed to be taken on 22nd. It was not listed.
We'll call it on 22nd of October. Call it immediately after vacation. Yes.
In the list, my item 61.
6-1
My
in the daily list.
My lord. Today's list, my lord. Well taken after vacation. Similar matter.
Who is your friend?
State matter. I've already said.
Can you give?
Already gave.
Yeah, after.
Similar matter in WPC number 2530/2025. Similar matter posted to after vacation. Matter.
Can I log along with WP number?
My lord.
Just give that check.
Oblige.
I am pardoned to
Call
mention.
along.
My lord, I am pardoned to mention. Item 10, my lord. On behalf of Akshay Kumar Sahu, his grandmother is hospitalized yesterday night. After vacation.
Right.
I pray for
After vacation.
Item 10. Mention this one.
This was mentioned actually.
My lord, yesterday night his grandmother hospitalized.
No issue. No issue. You tell your inimical friend also.
My lord.
My lord, item 1 on behalf of Subhas Mahapatra.
Item 1 is generally not mentioned, na? Anyway, you want time in this one? Top of the list.
They
have filed an application for adjournment.
That he took time saying that I will prepare an affidavit of apology.
But his application for adjournment says the matter was directed to be listed on 22nd.
Correct.
Monday.
Correct.
And since it has not been listed, now he's entered the puja, Navratri puja. So, beloved, my humble submission will be, let him be given time so that, he does not say that this was not considered, etc.
And after all, he wants to do puja. How we can come in the way?
And only a lordship can address this issue, my lord, with great humility, may I say so, my lord. Let it come after the vacation, as per whatever.
Which, sister, which date you want? Anyway, London senior advocate is saying you should be given time. That's right also. Yes. After all, if somebody does puja, we should prefer that. Some good sense will prevail sometimes after puja and other things. Yes.
After 2 weeks.
After 2 weeks, you want that. You choose a date from the calendar. Pull down a date from the calendar.
My lord, that week commencing 13.
13. Very good. Shall we call it on 14th?
Yes, my lord. My lord, may I only make one more submission?
Yes, sir.
That on the last date, your lordship had asked him to personally appear.
Correct.
That also, since she's there, your lordship may also say that.
Next date, he will be present
personally.
What's your name?
Bipasha Haldar.
Miss Mrs. or Miss-
Mrs. Vipasha Haldar.
Srimati signed, so appearing on behalf of party in person.
But 13th is what I was requesting.
13, very good. Very good. Requests time saying that party in person is performing Durga Puja and therefore his personal presence be dispensed with and he be granted time till after the puja days, festive days. First. She also tells the court that his personal presence be dispensed with for the day. First up. Next paragraph. Learned senior advocate Mr. Parida does not have very fairly submits, very fairly submits that matter may be the request of the party in person be allowed and matter be called after festival. First up. Next one. In the above circumstances, the personal presence of the party in petitioner in person is dispensed with for the day on the subject to the condition that on the next date of hearing he should be personally present before the court. First up. Call this matter on 13th. 10. Grateful. 42.
42 matters.
Sir, that day 42 matters. Kindly give another day. Yes.
15.
Can we have it on 15?
16th.
16.
Yeah.
Very well. 16. At the top of the list.
Top of the list. Grateful.
Very well, sir. Okay. I thought that you were here to object adjournment.
No. Let him have the full play.
Right.
Grateful.
That's right. Okay.
Say, please, your lordship, weekly list item 13, lordship. I pray for
Number
an
13.
weekly list.
So this board, right?
Lordship, pray for an adjournment, lordship.
15 you want time.
13, 1,
13 on the week. In the weekly list.
Yes, lordship.
Which year?
2025.
2025. Inform your friend also so that he may not wait in the court hall.
Lordship, state.
Government. After three. Yes.
Contempt petition is a retired person.
Retired person. Contempt case. But contempt cases are not treated as urgent cases, not. We'll have it immediately after vacation. Your senior told you to seek a shorter date. I'll call it on 8.
That's
Yes.
My lord, it's a matter which was due to be listed today, but it has not come up on the board.
It's not come up.
No, my
We can call this matter after celebrating the festival. Okay.
My lord, unfortunately, it's a little bit urgent. The vehicle of the petition has been blacklisted, which was used for transporting of the milk, my lord, from the Homefed factory.
But that was done a bit long. I had heard this matter.
My lord had heard this matter and
But
called.
that is bit not that very urgent matter. We'll have it on 9th of October. All right.
My lord, there is also another matter. My lord had heard it's a 2015 matter included, which involves the BDA as the opposite party. And my lord had directed us to file an application for amendment as well as addition of party. My lord, we have already filed it.
Generally, I do not direct amendment. I permit amendment.
My lord, I apologize, my lord, for the wrong choice of words. My lord, if it can come day after tomorrow so that it can be heard and notice may be issued by special messenger.
Day after tomorrow.
My lord, just for consideration of the amendment and it's a 2015 matter, my lord.
Anyway, if you are for 10 years, you have waited. Yes, have it on 15, 16. Okay. Yes.
Item 2. Item 2. Your lordship wanted instruction. I am to get, my lord.
Because the senior advocate pointed out.
Yes, my
there
lord.
Is a direction to the Tahsildar.
Yes.
So what has happened?
My lord, I had the instruction, but I am waiting for a written instruction from them.
So your lordship may kindly call this matter at 2 o'clock so that
Very well.
I can.
But whether, sir, will you be free? No problem.
No.
Even online also you can appear. Okay.
No, he will not appear. I have the instruction, written instruction letter from him.
I'm little surprised. I was little surprised yesterday that if somebody naturally 99% courts and judges, they say that it's non-appears when it dismissed for not prosecution. But your lawsuit directed to intimate me to appear, even though I had no instruction. So it's a pleasure to come. So
No. We should.
Yesterday,
you are part of the judiciary. What is fun in saying two wheels of the chariot?
no, that is all right. There is a jointing link, but there is here this wheel has got no joint link. The whole point is that you'll also know
They will not be visible. Sometimes things will not be visible.
No. The whole point is that currency note is such a thing, it is visible. And if it is not visible, it is not currency.
Very good.
Generally, professionals, they don't appear unless instructed. The two types of instruction. That's what I said also.
Yes,
But in spite of that also, you are also directed, and I was very happy. Long back, I told also that day, Justice Lingaraj Ratna had also equally directed like this. Because by then there was honor, as your lordship said, that the two wheels. And that was looked up in a respectful manner, and it was acted in a respectful manner at that time.
We should do that way.
Because that order was passed, just 1 minute, order was passed. A submission was made by a very senior counsel at that time, sometime in 86 or 87, I think, if I remember correctly. And it was completely out of pleadings. And I was for the petitioner, and I stood at that the entire argument is out of pleadings because counter had already been filed. So Justice Lingaraj said, is it so? I said, I filed affidavit. He was a very senior lawyer and is a very expert in taking interim orders. But incidentally, in that case, he was for the opposite party. It's a question of record. Then he dictated the order, whatever he submitted, he dictated and directed to serve copy of that order to counsel for both the parties. And we were served in the house. And that type of dignity, thereafter, it has been vanished. And now I am told that your lordship is saying that if somebody will speak in a low voice, 5 marks will be deducted.
I should be very strong.
But no,
the only way.
That has been long back gone.
Otherwise, how are you going to control us?
No.
Who will control us?
We have surrendered to your lordship.
No, that's bad thing. It should not happen.
What should
be
not?
Always.
Many things should not. Your lordship has come from the bar. Your lordship knows. I know a little bit of Bangalore, and also your lordship remember Justice Sridhar Rao. Once he had written an article, 2002, Criminal Justice System Requires Reform. I was terribly impressed. How could a sitting judge can write such an article that making a complete change. So I ascertained his number. I congratulated him. That it's sitting just impossible. To my knowledge, it is impossible to write to give such a concrete chain touching all the field. And because of the collapse of the criminal justice system, now we are suffering. What is the rate of conviction in our state? 3%. Horrible. It's horrible. It's a completely banana republic. If I know a client, in 7 cases, he ran from pillar to post. No FIR was registered. Chief Minister, Home Minister wrote, President of India wrote, yet no FIR was registered. He had to file complaint cases, 7 cases, about fraud of around 15 to 16 crores. And on 156.3, then it has been taken up as a case. And the human rights violation, 9 months has passed. No inquiry is being done. So it is almost a banana republic. The little bit, the manner in which it's not all are same. Since your lordship said, I became very happy that ordinarily I would not have come. But since your lordship having heard it that I don't have brief and I don't have instruction yet wanted to hear, then only I appeared because otherwise also I'm not keeping a little bit totally good health. Otherwise I would not have come. Generally the courts used to dismiss for default because non-appear. Here 20 years the client didn't come. I don't know the client. I didn't have the paper.
So, 25 years.
Yes, I stand corrected. 25 years. And
that afternoon 2 o'clock you will be free.
Yes. Sir, I will bring that. I will bring that instruction in writing.
Very.
I have the message.
Yes.
But I have asked him to give me a
letter in writing so that I can reproduce.
Exactly.
Okay. Then thank you.
Item 3.
But one thing, my lord.
Item 3.
25 years back, one of my friends said that, why don't you apply for senior advocate? I said that the rules which is there, it's very difficult to maintain. if I would have known that the rule is only there in the book and it's not to be applied, probably I thought retrospectively, I'm thinking that I should have mentioned, because my friends and some person, they got the application 25 years back and they got it. Of course, I was not interested, but the whole point is that I was told that the senior advocate, they don't mention. Even though I'm not a senior advocate, a particular, this Honorable Chief Justice said that you were not supposed to mention. No, sir, I didn't apply. I don't belong to that category.
Anyway, you are more
To
than a senior
enjoy the privilege of mentioning, I didn't. But the whole point is that what I see, that rule is there, it is not being followed. The senior advocate should not mention, and they should not be allowed also. Because the other things also should not be done, it is happening behind the bar.
Pardon me, Lord, my learned brother is not senior advocate, but he is a sincere advocate.
We treat him as senior advocate. Yes. Item 3.
Item 3, Your Lordship, this is a rehabilitation scheme matter, Your Lordship.
Huh?
A rehabilitation scheme. After the expiry of my mother, we both brothers, sons are unemployed, and I have
After the expiry of your client's mother.
of my client's mother. Client's mother. So I applied, but they rejected my application on the ground that there was some delay in applying the representation.
Yeah.
My fact remains, at that time, I'm sorry, at that time, they were unaware of this procedure. And secondly, at that time, the COVID-19 was at its peak, for which the medical certificate and all the relevant documents could
When death happened?
She expired on January 27, 2021.
January 2020.
My lord.
27 January 2020. But
The counter has been filed by them, but a copy has not been served upon me, Your Lordship.
not copy, sir. Please give copy.
Your Lordship can dispose because it is covered by the Hon'Ble Apex Court order and also the amendment.
To the rule itself.
Yes, that is our.
One order we had made in that, na? Do you have that copy of that order? Right now. Kindly be seated.
Yes,
please. The short grievance of the petitioner is as to
Passing on
rejection
the
of his or her his application for appointment on compassionate ground, the breadwinner of the family, namely his father, having died in harness on 27 January 2020. Learned counsel for the petitioner vehemently argues, Basanto vehemently argues that some delay was proved in making application for compassionate appointment is true. Semicolon. However, by that time, the COVID pandemic 19 had started shedding its shadow on the lives of people. Semicolon. Epidemic of the kind is treated as a ground for condonation of delay even by the apex court in a slew of decisions. Semicolon. That being the position, the rejection of the claim for compassionate appointment is unjustified. First. Next one. One more sentence. Lastly, he also notifies to the court the amendment of rules. Odisha Civil Services Rehabilitation Assistance Rules 2020. Wide notification dated 4th April 2025. And therefore, the rejection needs to be set at naught with a direction to consider the matter afresh at the hands of which respond, which OP. Sit down and answer. This is not a primary school. I get agitated when lawyers will stand up at this one. That's very bad.
OP 1 and 2.
OP is 1 and 2. Next paragraph. Learned AGA Mr. Lenka, appearing for the OPs, opposes the petition, contending that compassionate appointment is not a matter of right, the same being an apology to the principle of equality enacted in Articles 14 and 16 of the Constitution of India, semicolon. When rules provide by way of exception for appointment, the conditions prescribed by them have to be strictly complied with, and that having not happened, rejection of the claim cannot be faltered. First, so contending he seeks dismissal of the petition. Next, having heard the learned counsel for the parties and having perused the petition papers, this court finds force in the submission of learned counsel appearing for the petitioner as above. First stop. Very importantly, the amendment of the rule wide 2025 amendment dated 4th April 2025 also supports the case of petitioner. First stop. It hardly needs to be stated that the COVID-19 pandemic is treated by the apex court as a lull period for all practical purposes. And there was a specific direction to extend the limitation period in matters like this. First stop. After all, the rules of the kind are promulgated by the state for the purpose of mitigating the hardship of the family when its breadwinner dies in harness. First stop. Compassion is not unconstitutional. First stop. First stop. The justice of the case warrants that the impugned order be set at naught and matter be remanded for consideration afresh in a time-bound way. First stop. Next paragraph. In the above circumstances, this petition succeeds. Writ of certiorari issues quashing the impugned order dated 12/1/2023 at annexure made by who? District Education Officer. Wide annexure 4 or 9 it is. 4 annexure 4. Semicolon. A writ of matter is remanded for consideration afresh at the hands of District Education Officer Gajapati within a period of 8 weeks. Within a period of 8 weeks, all contentions of the party having been kept open. First off, it is made clear that the application shall be deemed to have been made within the period of limitation. No courts. It is open to solicit. Yeah. Item 4. Yes.
My lord, page 9 may kindly be seen.
9.
Page 9 of the brief. The petitioner filed a petition seeking
biological child of
issue of a legal heir certificate. This was the order passed. Then he went for appeal.
Why to appeal before the concerned court?
Then he went for appeal before the sub-collector. Sub-collector's direction is at page 11. Order may kindly be seen.
Page 11.
My lord, page 11. At the bottom, the order is there. He remitted the matter back to the Tahsildar for inquiry and for taking a decision. That was on
21/2/21.
That is yet to be complied with by the Tahsildar.
Kindly be seated. Petitioner's claim for airship certificate was rejected by the Tahsildar. void order dated so and so. Look into that. At annexer. Petitioner's statutory appeal against such rejection having been favored, comma, matter came to be remitted to the portals of Tahsildar for consideration afresh. Void order dated 21 February 25. Just look into 21 February 2025. First one. At annexer A2. First one. Next paragraph. Learned counsel for the petitioner submits that the claim is too short to be little, and the adjudication of the same after remand cannot be too long as if it is case one on the Bharati case. First of all, there is force in this submission. Next paragraph. Learned AGA 1973 Supreme Court Sciences. Learned AGA in all fairness submits that he would instruct the Tahsildar number 4 to accomplish the hearing and disposal of the remand within a reasonable period as may be fixed by this court. First off, however, he enters a caveat that all contentions of the party should be kept open. First off, with this proposal, counsel for the petitioner is agreeable. Next, in the above circumstances, 8 weeks. 8 weeks. Yes. Item 5.
Lordship, petitioner was selected to operate 2 numbers of cesspool emptier vehicle by the Khordha municipality. Lordship, there is a clause in the
vehicles bearing registration number so and so, yes. 1335, 1345.
Yes, Your Lordship. The petitioner was engaged to operate those 2 vehicles. Those 2 vehicles belongs to Khordha municipality, Your Lordship. And in the condition, there was a condition in this contract, Your Lordship. Page 26, Your Lordship, kindly have a glance.
26.
Relevant portion is para 3.5.
What it says?
It is service period. 7 years from the effective date of this agreement. After the service period, the vehicle will be sold at a depreciated value of 4.7 lakh each, and the operator would get
right to own the vehicle.
Yes, Your Lordship. After completion of the period, the petitioner opted for own these vehicles, and he made representations. But the opposite parties, without considering anything, now they are saying that you return the vehicle.
Where is your representation?
Your Lordship,
where is their order?
Your Lordship.
Your Lordship, kindly see Annexure 6. He has filed a civil suit.
You have filed civil suit also?
Yes,
PS number 270 of 2020.
Yes, Your Lordship.
We'll direct the civil suit to be disposed of at the earliest point of time.
They have disposed that. They feel that there is no urgency.
They said no urgency.
Yes.
We'll tell them now there is urgency.
He filed a petition under to waive the notice under
80 notice.
So that he made an objection. There is no urgency.
No, if it decided after 5 years, what would happen to the vehicles? Because you have fixed the price also. At what price you are going to give him?
Yes.
That also you have fixed.
And that about, Your Lordship, and our additional purpose is also with them.
The grievance is against the opposite party number 3.
3 is your client only.
No.
Person who has
1 and 2 the state. 3 is the executive officer Khordha municipality. So notice to go.
No, I will not make that order.
Yes.
What I am suggesting is just think that we will direct the civil suit to be tried and disposed of within 3 months. All right.
Till then, Your Lordship.
No, till then you have to make application there only.
Your Lordship, they have given in the annexure for the impugned order. They have said that immediately return those vehicles. Otherwise, they will take that vehicle. Annexure 4, Your Lordship, page 30.
I will permit you to make an application before the court.
Court will.
All right.
Yes, sir. Okay. That should be considered within a limited.
Petitioner's prayer, petition prayer is scripted as under. Next paragraph. Learned counsel for the petitioner, drawing attention of the court to the record, submits that although he has filed a civil suit in CS number so and so in respect of the very same cause of action, he is knocking at the doors of this court because the civil court concerned is not treating the matter as urgent, despite there being an application under section 80 of CPC 1908. First of all, therefore, he submits, the intervention of this court is warranted. Next one, can you be seated? Learned AGA Mr. Lenka, on request appearing for the OP numbers 1 and 2, opposes the petition, saying that it is not permissible to a citizen litigant to pursue plural remedies, subject to all just exceptions. Petitioner is already before the civil court and therefore his petition should be rejected. First up. Next paragraph. One more sentence. He also points out that since he does not represent OP number 3, if at all any effective order is to be passed, notice be issued to said OP. First up. Next paragraph. At this stage, learned counsel for the petitioner agreed with the suggestion of this court that a direction be issued to the jurisdictional civil court to treat the suit in question as involving urgency, or at least to consider his interim application, interlocutory. What is it called in civil courts in your side? Interim application. Have you filed any application?
Application, no.
Filed. Seeking reprieve. First time. Next paragraph. One more. This is appreciable. First time. Next paragraph. In the above circumstances, learned which court it is?
Civil judge, junior division.
Learned civil judge, senior or junior division? Junior division. Correct?
Yes.
No. Junior division.
Junior division, which place? Khorda. Is requested to try and dispose of the suit, which is in a narrow compass, within an outer limit of 4 months. 4 months. First of all contentions are kept open. First of registry to send a copy of this order to OP number 3.
Lordship, till then we have to purchase the vehicles.
It is open to the next one. It is open to the petitioner to make appropriate application to the civil court for interim relief, and if one is made, the court shall take a decision thereon on a war footing. Okay.
Grateful.
Item 6.
That's similar to Loknath Behra, my lord.
Just show it to your friend also. Next.
Item 7.
Challenging the rejection order dated 23/4/2025, the Land Tribunal had directed to give the retrospective promotion. Against that order, the government challenged before this honorable court dismissed. Thereafter, the government moved before the Honorable Apex Court. Apex Court was dismissed. And the government also 28/11/2024 directed to comply the order. And now, by virtue of this order, this honorable court directed to consider in light of Supreme Court orders. Now the opener too has rejected my case.
Rejected? On what ground it is rejected?
Rejected on the ground that he took
notice, Mr. Lenka.
Yes. Some other cases also you will see that.
Correct. Issue emergent notice. Mr. Lenka accepts notice. AGA Lenka accepts notice for Allotment.
Yes.
Okay.
Next is also same. Next also same.
It also same.
Yes.
Item 8.
Same.
Item 9.
Yes, 9. The mood matter. You that maybe because of vacation sometimes
That
there
was
is no.
item 10.
Huh?
That was item 10.
Yeah, 10.
Yes.
Okay, okay. But in that 9, read the prayer.
Yes, paid for area salary for the period 25/80/2011 to 6/1/2024. Here, my lord, you are involved in a vigilance case and
What happened to that vigilance case?
got conviction.
Conviction happened.
Yes, appeal is filed and on bail now. CRLA number 194/2017, pending before this honorable.
Conviction for?
Under section 13 PC Act, Prevention of Corruption Act.
But that you could have sent in your representation they have sent in 19/1/2024.
That,
Have you considered that representation? No.
no, that your lordship may say, but consider.
Petitioner's prayer is for a direction to pay the alleged arrears of salary during the period between 25/8/2011 and 6/1/2024. First off. All right, sit down, sit down. You want water? Sit down. Counsel for the petitioners draws attention of the court to the representation dated. Where is that representation?
Annexure 7.
19/1/2024 at Annexure 7, wherein the explanation is offered by the petitioner as to why she should be made the payment of arrears of salary. First of all, he argues that the said application of a representation has remained in the cold storage despite long lapse of time, and therefore intervention of this court is warranted. Next paragraph. Learned AGA Mr. Lenkov submits that the petitioner had suffered a conviction order in which is that? In DPC, order, and that her criminal appeal number 194 of go to the
194 by 2017.
17 still pends before the appellate court. First up. However, when asked as to why the representation is not considered, he in all fairness submits that he would instruct OP number?
OP number 5.
5. To immediately look into the grievance of the petitioner as has been heard in the subject representation and to inform result thereof to the petitioner if all contentions are kept open. First, with this proposal, counsel for the petitioner who came to court running like PT Usha, next part, in the above circumstances, 8 weeks. Open to solicit any information or document from the side of petitioner.
Item 11.
May I please, my lord?
Yes. You remove the fitting side, etc. I just say yes. Yes.
May I please, my lord? My lord, the petitioner has been terminated without being given any hearing or following the process of natural justice, your lordship. He was a contractual employee. Looking after the service.
Appointed down? He was appointed down? When was he appointed?
My lord. Engaged at 31/12/2012, your lordship. He joined on 1st January 2013.
This is engagement order 31/12.
Yes, my lord.
He was engaged as?
He's accountant come support staff.
Accountant come support staff.
My lord.
With graduation?
Yes, my lord.
For what period?
It was basically a contractual appointment, your lordship.
For what period?
It was initially for 1 year, but it was kept on.
Continued
Yes.
year after year.
Year after year.
Thereafter, they said don't come.
No, he was involved in a vigilance case.
Huh?
Yes. He was
Involved in a vigilance case.
Vigilance notice means what?
Police arrest, all the provisions of Corruption Act, Prevention of Corruption Act.
PC Act.
Yes.
What happens to that?
My lord. He was caught. Apparently, he was caught bribing, taking bribe for a favor which he couldn't have afforded. A favor which he couldn't have afforded. It's not.
But bribe is taken.
That is what the thing is. That is what that matter is just has started. The point is he has been bribed. The accusation of bribery is for showing a favor which he hasn't shown and he cannot show. My lord, there is a story because there is a story that is there. It's just a FIR has been lodged and he has been the case has been registered. The Apex Court has held that just because a case has been registered, the process of natural justice cannot be dispensed with.
No, you admit that you have taken money.
No, that is the point, Your Lordship. In fact, these contractual employees, what happens in these states, it's a very murky story. If Your Lordship allows, I will say. Because these are local level appointments. And what they do is they do not regularize these people, though there are past rules that they should be regularized after 6 years, but nobody is practically regularized. What they do, they can bring in a charge and remove somebody, and so that a new person can be appointed, new commission can be taken.
What was your stand in 313?
Well, that position hasn't come here yet.
Case is now pending.
Right.
But you were caught red-handed.
No, yes, it was somebody.
Whether that pink test phenomenon.
Yes, those
Arrested and now on bail.
is on bail and the case has been registered.
But this court is not meant for such people.
No, my lord, that's what is my humble submission. It is settled position of law that just because by registering an FIR or being implicated in it.
They will consider, depending upon the outcome of the criminal case.
So that's what the judgment, the Apex Court has held that without giving a process, following the principle of natural justice, just because there is a criminal case, the petitioner cannot be, an employee cannot be terminated. That's what is the.
Where is the termination? They have not continued you.
No,
That's all.
they have not. They have terminated me.
So where is that termination?
That is what is the order letter. Termination is at Annexure 2, Your Lordship, 1920.
But to such people, I don't.
No, my lord, it's
Yes, issue. Admit. Issue rule. AGA request of sub. Let it come up to 6 years. Yes. Next. Question, regular course. Regular course. Yes.
Item 12.
But this is covered by Lokanath Vaira's case. I am giving the corrected.
Corrected this one?
Yes. I have already corrected. Both the matters are same.
Yes. Different dates.
Yes. But I have corrected.
Okay.
Item 13.
May I please, Lord? This matter is with regard to reduction of grade pay, Your Lordship.
Grade pay?
Grade pay, reduction of grade pay from similar. Yesterday, one matter was there in item number 7, Your Lordship. Your Lordship was pleased to issue notice and state the Annexure 9 impugned order, Your Lordship.
13, na?
Yes, 13.
13.
Similar to yesterday, item 7.
Emergent notice. Mr. G, learned AG, on request accept notice for all office.
Yes. Yes.
All office. First one. An application in IA number 14834 of 2025, supported by affidavit, is moved, seeking stay of recovery. First off, counsel submits that this court has granted interim protection in WP number
25199.
25199 of
Up to 2025.
And therefore similar protection needs to be extended to his client on the principle of bearing. First of all, there is for submission.
Annex.
In view of the above, application having been favored, the impugned order at Annexure 9
At page 29.
stayed till next date of hearing. First of all, call this matter along with WP number so and so on. Right off.
Item 14.
May I please? In this case, the petitioner is the retired employee of the blood institution, madam, seeking pensionary benefits, madam. In the light of Hemant Kumar Chotai case, madam, similar matter is not issue notice and posted to after vacation.
It was notice was issued.
Issue emergent notice. Call this matter or agree. Mr. G accepts notice for all OPs. You appear for controller of accounts also.
Yes.
Controller.
Yes. OP6 matter to.
It's just accounting general.
Okay. emergent notice to 6.
OP6.
6. Call along with WP number.
2410225.
Write down it.
Already given, my lord.
Put that with the slip. Okay. Just put the staple and then put it there. So, yes.
Item 15.
My lord. Petitioner is a registered school, my lord. Registered under Registration Act, Society Registration Act 1860. And was
Your representation is to take action against the culprits.
Yes, your lord.
2, 3, 4.
2, 3, 4.
Let them consider. Representation is 22, 4, 25.
25.
Let them.
Small praise is there, my lord.
Yeah.
Then I call for the personal appearance.
Why?
Notice for the.
I'm not a magistrate. Magistrate has got power to call personal
It is
appearance.
representation 3, 4, and 5.
Why you
Several
want them?
issues.
You want to celebrate their marriage or what? Why they should be
There are
called?
several dispute facts, my lord. They have to be cleared and.
They have made representation, they will consider that. No, but petitioner's short grievance is reflected in the representation dated 24/5/2025 at Annexure 6, which reads as an reproduce entire representation. Otherwise, they will say, let him file one more representation. Reproduce it. Next paragraph.
Oblige.
Learned counsel for the petitioner submits that the representation remaining unconsidered for indefinite period of time is contrary to rule of law and the right to speedy justice, which is a facet of Article 21 of the Constitution of India, as has been repeatedly said by the highest court of the country. There is force in this submission. Next paragraph. Learned counsel for the AGA, Mr. G, appearing for the official OPs 124. Correct? Yes, 124. Official OPs submits, agrees with the suggestion of this court that representation of the kind should be taken up at post haste for consideration. And if a reasonable time is fixed, his client should accomplish the same. First, he enters a caveat that all contentions of the party should be kept open. First, next paragraph. In the above circumstances, petition is disposed of 8 weeks. Within 8 weeks, you should consider. When allegations are made,
Yes.
it is important that they are met. You may take decision this way that
My lord,
it needs to be stated that all the stakeholders should be given an opportunity of hearing it.
hearing, my lord. By opposite party number 4, probably.
OP number 4 to consider.
Item 16.
Oblige to.
Me agree, lord.
Yes.
Here, one advertisement issued by the government in the year 2006 under Annexure 1. For filling of
2006.
yes, for filling of the post lecturers. And pursuant to such advertisement, the petition was selected and appointed on contractual basis, and as on date is continuing. And around 72 lecturers were appointed.
Annexure 9 page, Annexure 9 page 39.
Regularization of,
Let me complete my.
There is a rejection.
he will be reading papers and it helps you.
No, let
Are you going to just argue for the
No, not argument.
satisfaction?
No, I'm not arguing. Just I'm placing the case. No, I'm not.
All right, you argue them.
No, you're not. I'm sorry.
Not waste the time of the court. He is adjusting.
Page 39 is the, Annexure 9 is the rejection order. That order was passed pursuant to your lordship's direction in WPC number 22989.
Direction was only to consider.
Yes, that the representation was take a decision on the, yes.
You take notice. It is relating to false cash certificates.
No. Regulation of service.
Regulation of service. But that aspect is also treated there, no?
No. Page 40 last paragraph, you'll also see the regime.
This ESC development.
They are appointed in SC Development Department.
Take notice.
Can I place me on this? Just 1 minute. You'll kindly see page 40, the rejection order.
40.
40 last para. The reason for rejection.
On the basis of prescribed recruitment procedure and by providing equal opportunity to all candidate, allowing the contractual junior laborers to be regularized in the regular post of postgraduate will be complete violation of the principles enshrined under Article 14 of the Constitution. Here they and distinction in the weight of any regularization is rejected.
They were rejected on the ground.
Threat to
On the ground that the writ appeal is pending. You know, for that's a page 40 last para. Only on the ground the writ appeal is pending.
but there no interim order, nothing.
No interim order, no interim order. Page 42 a lordship's order. Kindly see page 42 a lordship's order. Page 42 para 4.1. Page 43.
4.1.
Your lordship's order, 2 pages order. The order of the honorable single has been confirmed.
It provides for regularization.
Provides for regulation. There is direction for regulation. And on the ground of the pendence of the writ appeal, my application rejected. Now you also confirm this order of the honorable single judge. This is your lordship's orders. Page 40 starts from 42 and 43, 44 is related.
Division bench order.
Division, your lordship's orders, division bench orders. So, accordingly, now the whatever the region, that is no more in existence. This is my interface.
We do not know. Now, first time it has come now. Or any threat of termination from
The obvious is that is the amulets.
You have filed
I file application, yes.
Yes. Issue emergent notice. First up. Mr. G. Learned AG accepts notice for the OPs. Counsel for the petitioner draws attention of the court to IA number so and so, supported by affidavit wherein protection from possible termination of service because of the impugned order be granted is the prayer. First up. Counsel submits that in similar matters, the court acting on the apprehension of the parties has protected by way of temporary measure so that their means of livelihood is not put at stake. First, there is force in this submission. Next, in the above circumstances, this application having been favored, which OP?
The OP number 1.
OP 1?
One government. Because it is
One
lecturer.
is directed to continue petitioner service with the same terms and conditions as have been obtaining throughout till next date of hearing. Not till next date of hearing. Let that order be there during the pendant. Only that. Okay.
Item 17.
Yeah.
You're saying collective after.
Why interim order is granted? Yes. You appear to be in very haste. There is festival and other things. Enjoy that. Yes.
Item 17.
There is one, brother, 1 second. There is one famous book by Robin Sharma, The Monk Who Sold His Ferrari. He has written that book as if it is an autobiography of a Supreme Court lawyer in the US Supreme Court. All lawyers should read that. In Karnataka, I used to get letters from the spouses of the lawyers and the children of the lawyer saying that tell my papa to spend more time with the family. My papa has not spoken to me. Except he does not speak to me except on Saturday and Sunday. I think that he is my Saturday uncle. Spend time. Life is more important. Life is more important. Celebrate life. Profession is for means of livelihood. But you know profession also very well. I can understand. But you should not have anxiety. Spend time with these spouses. I have friends, relatives.
Actually, we are interested to praise the matter of your lordships. This is my anxiety, so anxiety of the bar.
But I spend a lot of time with my family. Yes.
Item 17.
Yes. But that's 17.
Item 17 prayer is
Airship certificate.
My lord,
So it's the legal layer
legal layer certificate. Issue.
instead of legal layer certificate, she says succession certificate.
Yes.
How can we say all that?
How can it be adjudicated here?
That's what. But legal layer certificate, she is a writ of prohibition actually.
Oh, my lord.
Post after
That's it.
vacation to enable counsel for the petitioner to come and argue. Yes.
Item 18.
My lord,
Yes.
matter related to revise of scale. Similar matter already issue notice. Madam.
Issue notice, G accepts notice, call along with WP number. Yes.
Item 19.
Yes, sir.
Small matter, the petitioner is a retired employee and playing for RSCP, a revised assured career progression scheme and by
Similar matters we have posted in October, no? Similar matters we have posted in October.
Yes, there is a order of rejection.
Rejection is there.
Rejection is there.
Then we have to consider it. I will take notice.
My lord, let's submit.
My lord, they have rejected on the flexible ground because by annexure 3.
No, I am agreeable to issue notice now. Will issue notice.
On the
Fixing a very short date because petitioner is a retired employee and getting very.
Issue emergent notice. G accepts notice for the OPs. All OPs.
Oh,
yes.
All OPs. First up. Since petitioner is a retired employee, call this matter in the first week of November 2025. All.
Item 20.
My lord, pardon to mention. Item 17 can be passed over.
17.
Yes, ma'am.
We have posted it, that legal airship proceeding. There's no interim order, nothing.
No, it says, my senior counsel is another court.
There's no interim order.
Appearing, my lord. My lord, I'm
Yes.
appearing.
Yes.
My lord, in this matter relating to my lord. My lord, here the
You are saying
petitioner
that
file
succession
application
certificate
for
should be obtained.
issuance of legal hair certificate.
Dropping of legal air proceeding.
Succession certificate to be obtained. I am the natural born attorney. The RI has conducted the inquiry and found that I am the legal heir. Your lordship knows what is the time will take, the time consumption of time with regard to succession proceeding. Well, in the succession for succession certificate, I will have to approach the civil court. Well, the RI inquiry is clear. The inquiry of the RI has made that I am the daughter of the year.
Issue notice. Issue notice.
Yes, sir. Yes, sir.
Let us see. All. Next.
succession.
I don't know.
Oh, okay.
My lord, I'm assistant teacher, my lord.
Yes.
Proceed, kindly turn to annexure 4, page 14. I was sanctioned arrear salary of 4,35,631. This money was not disbursed in my favor. I made a representation and a grievance petition.
Not considered.
My lord, your lordship will kindly see the reply given to me at annexure 1. They have said that one junior clerk has siphoned that entire amount. FIR has been filed, and once that case is over, then I will get my money.
That case will not be over in 25 years.
During my lifetime.
What for, Mr. G?
Government has sanctioned the
He
money.
will say it is because of judges like you, those cases will not be over.
Government has sanctioned the money. Another clerk has, government employee has followed. I will have to wait till my death to get that money.
In second year of law, we had administrative law. Our professor, my professor was a great teacher, a doctorate from SJD University, etc. He used to teach us administrative law. He quoted one decision. He asked me to, Dixit, you read this judgment and prepare note and give me. That was, I remember, State of UP versus Kasturi law.
Custody law.
Kasturi law.
Yes.
The sovereignty of the state, the sovereign functions of the state. So many things are there. In that case, the golden ornaments of the petitioner were seized by the police. And that was put in Malkhana. We don't know what you call in your state.
Malkhana.
Malkhana one police constable took all that ornament, ran away to Pakistan.
Pakistan.
Then this person applied for return of the articles under section 457 of CRP. Then state said the arrest and detention and also seizure of the things were done in exercise of sovereign power. And what is done in sovereign power, it does not amount to tort at all. Therefore, Article 300 is not applicable. The sovereign function, therefore, you should go home without ornaments. It's very interesting. Of course, thereafter, many judgments, Vedavati versus Rajasthan, Vidyavati versus State of MP. So many judgments have come. Squeezing the scope of sovereign functions. It's like this only. He has run away and therefore you should go and chase him. Can you say that?
That is what they want to say.
Can you say that?
No, Malay.
They have advised in two ways. Either to wait till that case is over or go to court.
Go to court.
Go to court and get the order.
Therefore you are here now. They have strictly advised you. They have said to go to the criminal court. Mr. G, why can't some sense prevail in the government circles? Yes, emergent notice. The G is requested to accept notice for the OPs. First off, since a short
Adjournment.
Question is involved, post this matter in the first week of November.
I will serve copies.
Emergent notice to 6.
If you lordship want that, I will take.
So that person who ran away.
Yes.
He will not come in here.
I have made him a formal party, my lord. Actually, government has to pay.
Yes, notice.
I will serve extra copies on my lawn.
6 is dispensed with.
But in our side, he cannot run away.
Because roads are not that good. Yes.
Item 21.
I am challenging Annexure 9 and 11.
Yes.
My lord, in directing me to pay the entire land value along with the penalty, which is contrary to the Annexure 2 and 3. I have applied for a land. I have applied for establishment of a warehouse. My application was processed and it was also recommended to the IDCO to give me a land so as to establish the warehouse.
35 lakh 20,138. Of that, you pay 10 lakh 60,620.
Yes. It is in accordance with Annexure 2. Your Lordship may kindly turn to Annexure 2. Annexure 2 is a circular issued in 2020, wherein there is a provision to make payment on installment basis.
But your allotment happened when?
My lord, in 2021, my application was allowed and they have, your Lordship may kindly turn to Annexure 3. Annexure 3, page 13. My application for payment of the entire land value on installment basis was allowed.
Was allowed?
Yes, by the Annexure 3. And accordingly, I have paid the entire due in 2023.
You have made entire payment?
No, only installment.
Whatever installment is falling due, that you are making.
25%.
Now they are saying entire money at a time.
Yes.
On what ground?
My lord, that is the for which I am before your lordship, or else it will be cancelled. Your lordship may kindly turn to another fact, Annexure 2, subparagraph 3. In case of payment of land cost through installment,
following procedure shall be followed.
Yes, and the allotment letter will be issued after payment of the first installment.
25% of the land cost.
Yes.
In 10 lakh out was 25%.
I have paid the 25%. No allotment letter was issued and they sat over the matter. Thereafter, they have issued Annexure 9 and my request to review it was also rejected by Annexure 11.
Yes, who are the parties?
It is IDCO, Industrial Development Corporation.
Emergent notice, returnable within 4 weeks. First, an application in IA number so and so is moved supported by an affidavit, kindly be seated. Seeking reprieve against the impugned action. First, learned counsel draws attention of the court to the record which a prima facie vouches that she has been granted easy installments and that she has been making the payments as and when the same fall due. First off, there is a specific order providing for grant of each installments. And therefore, the impugned order could not have been passed, tells the counsel. She also adds that if reprieve is not granted, the very allotment itself might be cancelled, as has been now written in the impugned orders. First, a prima facie case for grant of reprieve is made out. Next paragraph. In the above circumstances, the application having been favored, there shall be stay of impugned orders or any action pursuant thereto. First. Yes. Next.
Item 22. Place.
All web copy to be acted upon them.
Urgent copy of fellow.
Yes, it will be a copy.
22
Posted today.
22 on way about Jack and Kamal after recess, madam.
After recess?
Yes.
After 2
p.m.
Okay.
Yeah. Item 23.
The matter relates to my lord, retired block grant teachers. That could there is a cover.
My lord, notices has been issued. Similar matter is pending before the judge.
It is posted on which day, do you know?
That was on 11th. Further it has been
Thereafter, it did not reach the appearance. 22. Anyway, issue emergent notice. KGA
28.
He accepts notice for all OPs. All OPs are governing body goes to
Government, they will send the
OP 1, 2, 3. Emergent notice to OP 4. All this matter along with WP number. Do you have connected copies, sir?
That is Hemant Kotra. There is covered on Hemant.
No. Similar matters notice has been issued by this and
somebody knows. Perhaps you have filed many cases.
Item 24.
Yeah, give any.
Item 24 today's item. 24 more. No. 14 item 14.
14.
Man.
I'll call along with item number 14. Okay.
Item 24.
Here the petition is a junior clerk. Upon the rehabilitation assistance scheme, my lord. The area salary has not been paid, and yesterday items 15, my lord. Similar case. You will also dispose of the matter. Same order has to pass in this case also.
Same order?
Yes.
Yesterday's 15 to consider your representative?
Yes, keeping in view Annex 15 that the coordinated bench decision, her direction has been made to dispose the salary within 15.
The subject matter of this petition, learned counsel for the petitioner submits, and learned AGA does not dispute, is substantially similar to the one in WP number
25992.
25992 of 2025.
Yes. Yesterday item 15.
Wherein a direction has been issued to consider
OP number 1.
Issued to OP number 1 to consider the similar representation. First off, learned counsel for the petitioner submits that similar case should meet the similar fate at the hands of state court, and there is forcible submission. Next paragraph. In view of the above, petition is disposed of 8 weeks for consideration, and to inform, etc. Solicit information if necessary from the petitioner. Okay.
Sir, my lord, annexure is available at annexure
16.
They are available.
Keeping in view Annex 15.
Annexure 16 in the light of Annexure 15.
And next case is also same, man.
Next
Sub-item same. Yes.
Item
same annexure?
Same repent date also same.
Okay.
Item 25.
Yes.
Maybe, Lordship. The petitioner before your Lordship was a Shiksha Sahayak. He tendered his resignation, your Lordship, from the job.
The direction for reinstatement.
Thereafter, he had filed representation to withdraw the representation.
But it was, when did he tender that?
He tendered resignation on 26/7/2024.
26/7/2024.
Lordship.
And he filed with the fought with his spouse.
Thereafter, your Lordship had Annex 3.
When it was accepted?
Accepted, your Lordship, on 1st August 2025.
1/8/25.
Lordship. Page 19, Annex 6.
When did you apply for
withdrawal, your Lordship?
Withdrawal of
Again, for joining, your Lordship, I have submitted my representation on 6th December 2024.
What was the reason for resignation?
The reason for resignation was personal difficulty, your Lordship.
What is that? Everybody will have personal difficulty, including my driver. What is that personal difficulty?
I am further to inform that
There cannot be international difficulty in man's life.
Lordship, that is, I have specifically mentioned that is in the present service engaged contractually without any assurance of regular service.
Therefore, he left it.
Lordship.
Now, is there any assurance?
No, there is no assurance.
Then there is no change of circumstance.
The thing remains, your Lordship, by that time, because by virtue of an order of this Honorable Court, and that has been confirmed by the Honorable Apex Court, that contractual employee of Shiksha Sahayak of such category, 552
Had he been continued, it should be. He resigned the post.
Yes,
Went elsewhere. 6 months are over. 5 months are over. And now all of a sudden he realizes some Jnanodaya happens and now he makes the representation. How? Supreme Court said in, I think, Indira Nehru Gandhi versus Union of India, there is one paragraph as to how resignation would operate.
With due apology, may I submit, your Lordship?
Why apology?
I rely upon a decision, that is AIR 1978 Supreme Court, wherein at para 51 it has been held that it will be where repetition, your Lordship, that the general principle is that in absence of a legal, contractual or constitutional bar, a prospective resignation can be withdrawn at any time.
I will tell you the law relating to resignation in a few sentences.
Lordship.
Number 1.
Lordship.
Right to apply for resignation is ordinarily regulated by the rules of service. An employee is entitled to apply for resignation even without assigning reasons, whether it's personal or international. He need not assign it. Once resignation is voluntarily given, it is open to the employer to accept it. Subject to rule. Suppose if the rule says within 30 days you will not accept it, you will not accept it. In ordinary law, once resignation is accepted, you cannot seek withdrawal of resignation because resignation loses its identity with acceptance. And the vinculum juris of employer-employee comes to an end. In extreme cases, courts have said, even after acceptance, if an application is moved very fast, in a short period of acceptance, generally it should be covered if the post is kept vacant and an explanation is offered. Otherwise, you cannot come back. And acceptance is a must, but communication of acceptance is not required. Like under the acceptance of contract, it's a little different it is. This is the law relating to acceptance of resignation, which is the change of circumstance. There is no change of circumstance.
I cannot be regularized, your Lordship, because the school committee as well as
there is not right now. Petitioner had applied for resignation while letter dated 26/7/2024. Kindly be seated.
Lordship.
24. And the same was accepted on 1/8/2025. First. Thereafter, he made an application on 6/12/2024 to withdraw the accepted resignation. First. Next paragraph. Learned counsel for the petitioner submits that his application for withdrawal of resignation ought to have been favored, there being change of circumstance. Namely, earlier when petitioner had applied for resignation, he was under the impression that there was no scope for regularization of his service. However, now, because of the law declared by the apex court in Jago, etc., the hope for regularization has arisen. First, next paragraph. Learned AGA Mr. Mohanty opposes the petition, concisely stating the law relating to resignation, that once resignation is accepted, the vinculum juris of employer-employee comes to an end, and in the absence of any plausible reason being shown, ordinarily the request for withdrawal of resignation is not favored. First, this court is in complete agreement with the submission. Next paragraph. In the above circumstance, petition being devoid of merits is liable to be rejected, and accordingly it is. Next.
The connected application is also similar.
Same.
The connected one.
Okay. One order. Not separate order. Yes.
This is a recovery matter, also already issued notice and stay the recovery.
Same. Issue notice. Next.
Item 27.
There is one judgment actually, Bank of Baroda versus so and so by Justice Thakur of Karnataka High Court. Can you take out that judgment? When Madhumita Bachi, some advocate, had argued that matter. Bank of Baroda, Bank of India, something like Bank of Baroda, it appears. Bank of Baroda versus. No, this is Justice Tirat Singh T.S. Thakur of Karnataka High Court, long ago.
For acceptance, one has a right to withdraw.
No, even after acceptance.
Yes.
He quoted 1983 Supreme Court.
Yes.
Only limited the scope because man's life is like that.
Limited scope.
Anyway, just look into that judgment and place it on my table also. I want to really refresh my memory on that.
Item 27.
Yes, sir.
Item 27.
27. Must be prayer.
This is in respect of the
To reconsider the grievance of the petitioner
PTF school
for regularization of
regularization, and they have filed this representation also available at number annexure number 23 main.
Two representations.
Yes. So 23 is the last one, my lord. It is at page 75.
Consider that.
Hey. This is on 7/3/2025.
If we pass order in the absence of lawyer, he may take a fee on the ground that he has argued the matter. So we call this matter of provocation to enable counsel for the petitioner to come and argue. Yeah, that should not be a fraud on client also. Yeah. Next.
Item 28.
Before vacation, this is for vacation.
Yeah, call that matter earlier. The short grievance of the petitioner, vacation, festival, some extent.
Get his peace.
No, he might be detained in somewhere else, not.
Is reflected in para 3 of the petition. 3 and 4. First. Next paragraph. Petition is accompanied by two representations dated 7/3/2025 and another is
That is one reference.
one
Page 75, it ended to 78.
6/4/2020.
That is the earlier one.
Wherein essentially a request is made for regularization of service of the petitioner. First up. When such representations are made, the state being a model, a constitutionally ordained model employer, why that was some judgment that Bhupendranath Hazarika versus State of Assam, a decision has to be taken by the authorities on such representations. First, that having not happened, interference of this court is warranted. We will not say anything about the lawyer's argument. Only we will say first. Learned AGA, Mr. Mohanty, on request appearing for the OPs, opposes the petition, saying that unless right to consideration is established, there can be no direction for consideration of such representation. First, having so contended, he fairly agrees to instruct the OP number 2.
Yes, ma'am.
OP number 2 to look into the grievance of the petitioner as has been aired in the subject representations in a time-bound way, if all contentions are kept open. First up, this is fair. Next paragraph. In the above circumstances, petition is disposed of 8 weeks. Open to solicit, no course. Yeah. Item 28.
Matter relates to MD law, not assigned to the yourself's bench.
The registry to verify and reclassify the matter and further to post it before the roster bench. Next. Item 29.
Well, in this case, the petitioner claims to include him under the OCS pension rule 1992. Earlier, the approach before this Hon'Ble court, and the direction was issued to the opposite party, and the opposite party, by the Annexure 9, he rejected his case,
On what ground?
On the ground that since your regulation was made in 2013, so you are coming under the NPS scheme, but my
take notice.
Because 2005 is there, for that.
Take note. AGA for who are your opponent?
If AGA will take notice from operator 1 to 4. 1, 2, and 4. 3 will be independent.
Emergent notice to 3.
No.
Yes. Item 30.
So if I may please your lordship, my lord. My lord, the petitioner challenges the order of the year 2013, wherein the pay fixation of the year 1989 has been done and changed. After the retirement of the petitioner,
they have recovered that money now.
My lord, they have recovered the money after retirement without issuing any notice.
Take notice.
Your lordship.
AGA to accept notice. Matter lies in a narrow compass, call in first week of November. Yes.
Gratefully, lordship.
Item 31.
Wait, please, my lord.
Yes, sir.
The order of disengagement is under challenge. And is
25.
My lord. The similar matters, interim order has been granted, and your lordship also clarified in subsequent order that they should allow to continue on core 8.
Issue emergent notice. First one. Petitioner draws attention of the court to IA number 16321 of 2025, supported by an affidavit for grant of reprieve in the nature of an order, interim direction for continuing the petitioner in service as resource, ignoring the disengagement order dated 6/5/2025. First, counsel relies upon several interim orders granted by this court and coordinate benches of this court, wherein reprieve of the kind has been accorded to the litigants since their livelihood depends upon the job, since the very job is at times the livelihood of their means of their livelihood. First of all, there is force in this submission. In view of the above, the impugned order of disengagement is stayed, coupled with the direction to continue the petitioner in the job as was before. Okay.
Along with all this matter.
All along with WP person.
Obliged.
Okay.
Item 32. 32, my lord, on behalf of JKN, taken out 2 p.m.
Taken up after the vacation?
No, 2 p.m. my lord.
2 p.m.
Yes.
Suppose if I take and grant the relief to you now, do you have objection?
On behalf of JKN.
Huh?
On behalf, highly with Mr. JKN.
Who is the on behalf?
On behalf of JKN.
Will issue notice. There is no interim prayer, etc.
My lords, notice to go, my lords.
Notice has to go, na?
Because other parties are there which I can
Also, 22, my lord, taken out already till 2 p.m. my lord. This matter will be taken out 2 p.m. my lord.
No, even then I will make the same order. All right. Issue emergent notice.
My lord, there is an interim application is there.
Interim application, therefore you have come along with him.
No, my lord. Mr. Lekka is busy in one of his function. His 16th birthday of his.
What is the interim order you have sought for? Go to application.
My lord, the candidate petitioner has been selected against the physical handicapped post. And they send the matter to the medical board and the doctor. My lord, let it be 2 p.m. Brief with Mr. Lekka.
Two advocates, namely so and so, vehemently argue that this is an eminent case for grant of interim prayer in terms of application in IA number 15861 of 2025, supported by affidavit. First, they together submit that. Unless one post of junior teacher schematic, into brackets, schematic, science, meant for a physically handicapped category is kept reserved, comma. Petitioner may be put to prejudice. But they also tell that no prejudice will be caused to the other side if one single post is kept vacant till the next date of year. There is force in this submission. Next, but in the above circumstances, application having been favored, the OP number 3 is directed to keep one post of the kind vacant till next date of year.
My lords, provided there is vacancy.
Provided such vacancy is still available.
Man.
Do you have objection now?
My lord, that selection will be exhausted by 5th of October.
We have said keep one post vacant. Your senior will come at 2 p.m. again to argue.
No, my lord.
Okay. You take senior for party, saying that you have procured one order. Okay.
Item 33.
3.
May it please the Lord says. The brief facts of the case is like this, my lord. In 2014, while the petitioner was working as an assistant teacher, he was suspended. My lord, he was suspended, my lord. In 2015, immediately he was revoked. That suspension order was revoked.
When he was suspended?
2014, my lord.
Why don't you?
December.
In this court, there is no culture of giving the date at all.
My lord, December 2014, my lord.
Date is not given.
12.
No date is given.
My lord, 2012, 2014.
2012, 2014.
My lord.
1-4.
Yes, my lord.
Yes.
Then again on 19/5, 2015, he was being reinstated.
Yes.
The suspension order was revoked, my lord. In 2017, my lord, 21/6/2017, there was one disciplinary proceeding initiated against the petitioner.
21/6/2017,
my lord.
Yes.
My lord, so there is a dead chat.
My lord,
Lordship,
I've given
yes,
that, my lord.
Okay. B.
List of which I've given. But what is the what has happened after that, my lord? The inquiring officer, my lord, exonerated from the petitioner from the charges, my lord.
Yeah.
Then the disciplinary authority again, my lord, appointed second inquiring officer on the same charges. My lord, then petitioner was punished, my lord, on that, my lord, ground that he was being punished and one increment was withheld, my lord. Then he has challenged that order before this honorable court. This honorable court, my lord, quashed that disciplinary proceeding and granted all the consequential benefits to the petitioner. Then I approached the authority. They did not listen to me. I filed one contempt petition. During the pendency of that contempt petition, they have granted me only the financial benefits, but not the benefits of promotion and, my lord, the gradation list.
Consequential benefits.
Other consequential benefits, my lord. They treated this order as if that is only restricted to, my lord, the financial benefits. I say, my
all
lord,
benefit ought to have.
yes, my lord. Consequential benefits includes all the benefits.
If you-
And I have got a judgment entirely
Permit
covered.
me to, no, I'm finished. Still you want to cite the judge?
No, my lord, no. Sir.
For a notice, you have made out a case.
My lord.
Emergent notice, there, Learned AG accept notice for me. Okay, I shall be back in minutes. Yes, sir. Item 34? 24.
May I please your lordship?
Yes. Sir.
My lord, on behalf of Jasprit Kaur, my lord, I am equal pay for equal work, my lord.
So pay for Dilip Roy.
No,
Yes, Dilip Roy, na?
yes, yes.
Dixit Roy.
My lord, here there was no cause of action. Let him make a representation first.
I pray for similar order, my lord. Earlier, by this honorable court.
Sure, to your brother.
Yes, master.
You will copy. Yes, we have said the same thing, na? The Dixit Roy, right? I forgot this. Yes.
My lord, my name should be mentioned.
Your name should be mentioned. No, I will mention some other thing. And my name also.
Item 30.
Sorry, may I please?
Yes, sir.
Yeah.
Item 35.
May I please?
Item 35.
Yes.
Your my lord, the petitioner is a landless person and he is in occupation of a piece of land since the time of his forefather and they are also staying there. But in the year 1991, a proceeding under the provision of Orissa Prevention of Land Encroachment Act was initiated. So pursuant to the notice, he appeared before the Tahsildar and filed an application for settlement of the land in his favor. That is all. There is also a provision in the OPLE Act that the land can be settled if it is found on inquiry that he is a landless person. There are two mode of settlement are there. But however, he filed an application that was considered. He also paid the penalty and it was decided that the land should be settled in his favor. And accordingly, decision was taken to settle the land in his favor. And you lost that Annexure 4, of course, it is Oriya. But he was
that was decided on which day?
He was directed to appear before the Tahsildar on 22nd 6 1992.
No, you say that settlement order was made.
Yes, the settlement order it has not been given to him, but he was directed to remain present before the Tahsildar for the purpose of receiving ROR, record of right. That after recording the land in his name, the record of right is to be issued in his favor, that is Annexure 4, and pursuant to that, on 22nd 6 1992, he appeared before the Tahsildar. However, the ROR was not given to him. Thereafter, he ventilated his grievance before the collector. When it was not considered, he approached this honorable court in the earlier writ petition. That is, Lordship get.
Yes, I saw that.
Yes,
WP 3792 of
3792 of.
What was the order there?
The final order Lordship will get at page 26. But a direction was given to the Tahsildar that since no decision has been taken, take a decision. Until then,
shall not disturb.
It shall not disturb him.
Any decision is taken?
No, my lord. That is, no decision has been taken.
Yeah.
In the meantime, the Tahsil office is changed. Initially, it was under a Tahsildar, that is Tahsildar Naurangpur. Now it has been changed to another Tahsil. A new Tahsil has been created.
He has to consider that.
Then he has to consider the same. So
Suppose we make one more order and another Tahsildar is.
How? Normally it will not happen, my lord.
There is already an order, na?
Yes, that is already an order.
Till decision is taken, you don't disturb him. That's all. You don't take decision.
My lords, here is unauthorized occupation of half an acre of land.
And half acre.
48 cents.
That is nearly half acre.
As per the guidelines, the landless person will get only 4 decimals of land. And he is not entitled to that land also. Government may give anywhere. So, my lords, now from the averment, it is required for public purpose, construction of something.
All right, you take, but you give land to him.
My lords, let
the order may be complied.
There is a direction by the coordinate bench.
I have seen that.
Now, since there is a direction, you can't, wherever you want to give him. If your rules provide. Maybe that.
Let Tahsildar take a decision, my lords. My lords, now instruction is not with me. And there is already order.
That again, one more order, if I make also, again he will be made to come before the court for yet another order.
Yes, my lord. This is under the provisions of Prevention of Land Encroachment Act. That is not assigned to my lords also.
Not assigned to you. Registry to reclassify the matter and post it before the procedural bench immediately. Okay.
Item 36. 36, my lords, the part-time physical education instructors regulation matter.
Covered by judgment.
Yes, I have already given the corrected copy.
Yeah, just show it to one.
Yes.
Copy, just show it to Behar also.
Yes. Already given.
That part is.
Item 37. All connected matters, sir. Case relates to regularization matter, identical matter, your lordship has issued notice and also granted interim protection, my lord. That is, I have given that 37.
Yes, doctor, just look into that. Right? Do you understand?
37 and also 47 your lordship also.
37 and 47.
My lord.
In 37, 2 matters.
My lord, that is 4 matters, your lord, 3 matters.
37 and 47.
My lord. 4 matters.
All right, same entry.
My lord.
Call along with each other. Yes.
Madam Lordship.
Yes, yes.
My lord, on 15/5/2017, disciplinary.
Nani is your opponent?
No, ma'am.
No, then you are safe. I am also.
On 15/5/2017, 15/5/2017, disciplinary proceeding was initiated against the petitioner on the ground of misconduct and dereliction of duty. My lord,
Dereliction duty.
and dereliction of duty.
Dereliction of duty.
My lord, on 10/8/2012, the petitioner was transferred from Pulsara block to Purusottam block, violating the guideline.
10/8/2012. Which election it was?
No. Transfer order was passed, violating the guideline dated 15/5/2012.
15/5/2012.
Guideline. So some of the teachers, they approached State Administrative Tribunal, Cuttack bench, challenging this transfer order. Yes. And some of them, Sikhya Sahayak and Gana Shiksha, they approached Hon'Ble High Court of Orissa, challenging this transfer order. Yes. That was reported in 2013-1, OLR 432.
Saying
that transfer order was challenged.
What the report was? The reported judgment says what?
They quashed, the Hon'Ble High Court of Orissa quashed the transfer order because it is in violation of the guideline 15/5/2012.
All transfers are quashed.
Quashed. Then
tribunal also quashed and High Court also quashed.
pursuant to tribunal's order, the 10/8/2012 order was modified twice. Twice the order was modified.
Yeah.
When the petitioner was on leave on medical ground. When the petitioner on medical ground was on leave, at that time during the leave period, 10/8/2012 transfer order was modified twice. First on dated 7/9/2012 from the Kolitaspur to Bhutta Sarasangi, it was modified. Then again within a period of 1 month, it was modified. Again on 29/4/2013, again it was modified from Bhutta Sarasangi to Baudiapalli.
So several transfers were made.
During the leave period.
Yeah.
But the petitioner has not received any of the transfer order.
He was incommunicado.
Yes.
Did he go to any forest? Did he go to any forest?
They have not at all communicated. I have obtained the RTI report. On 29/4/2013, the transfer order was modified to his home block, Pulsara block, which is just 5 kilometers from his house. So if the transfer order would have been communicated to him, he would have joined it happily. It was not communicated.
What is your prayer?
My lord, I have filed one writ petition, several writ petitions. This is the 8th time.
8 writ petition?
Yes, my lord. Means he has spent 1,50,000 to get justice.
Your client appears to be court bird.
Last order, my lord, on WPC number 21977 of 2024 was filed.
What happened?
The matter was admitted.
It is there now?
No, it is disposed of.
Saying?
My lord, I'm coming to the point.
Yes.
The matter was admitted.
Yes.
Honorable Court directed to serve 6 extra copies.
So what happened to that?
I have served 6 extra copies.
You xeroxed all 6 copies. The Xerox man received money and you paid.
I have filed RTI reply, which shows that these transfer orders was not communicated to me.
Yes.
But without waiting for the without giving an opportunity to the state to reply the averment, the Honorable Court disposed of the writ petition on dated 21/2025.
Yeah.
Directing the opposite party number 3, collector, to conclude the disciplinary proceeding.
Within what period?
Period has not been mentioned. To conclude the disciplinary proceeding.
They have not concluded.
No. Till date, they have not concluded.
That order
the disciplinary proceeding is of the year 2017.
2017?
G.
So and when the direction was given, sister?
Yes.
Direction by the coordinate bench?
That is the last...
latest...
28th January.
28th January.
25.
In this writ petition, my limited prayer is
certain.
There is a limited prayer. Let the opposite party number 3, collector, verify whether the transfer order is communicated. Means I have received the transfer order, all this transfer order or not, before concluding the disciplinary proceeding. And my second prayer is that necessary direction to the opposite party
to re-examine
inquiry report and to appraise whether the view.
My lord, same prayer was made in WPC number 21977 of 2024. And considering everything, this Honorable Court has already dismissed the applications.
Dismissed the applications. But anyway,
phase 129.
This is not prayer then.
28/1/2025 order was made to conclude the inquiry.
My lords, that...
now we are in fag end of September.
My lords, that what is the stage? I don't know.
It concluded.
Not yet concluded. Therefore, Madam is rightly saying in her lengthy argument that justice is not met to
my lords. My lords may pass
order. The learned judge passed the order and you have not obeyed it. My order also will meet the same fate. Why unnecessarily?
Yes.
2012 and
First reading.
2017. inquiry.
Several rate petitions were filed.
All right. What to do if litigant comes? A lawyer has to file the case. Otherwise, what lawyer should do?
How to get the
I'll take instruction then, your lordship.
The lawyer has to get justice.
What is this test?
client has to get justice.
My lord.
My lord, RTI reply. This is English translation of the RTI questionnaires.
Why you have said everything? I remember now. Now, madam is saying,
My lord, kindly
so many copies of transfer orders she has obtained in RTI. These orders were not communicated to madam's client.
No, my lord.
Now, they say, you verify whether these were communicated to her client. And in the light of outcome of verification, re-examine the report. Very innocuous prayer. How can you say no to this?
My lords, kindly see the prayer. The very same prayer was made in the earlier application.
But even if that order was made, where have you concluded?
And my lords, she can raise all the points before the disciplinary authority.
Some other festival is coming. Madam has to celebrate festival. How can we send her empty handed?
Your lordship praises.
I beg your pardon, my lord.
Yes. Yes.
They have communicated when during 2017, when the contempt petition is pending, in the show cause reply, they have annexed a document.
Well,
But my grievance is that I have not received.
now you have to permit me to pass order.
I have not received. Whether I have received.
No, if you permit me, I will pass an order
Yes,
in
my
your favor.
lord. Yes, my lord.
Okay, kindly be seated. You argued very well. Everybody has understood your case, not only judge. Kindly be seated. Vasanto. Vasanto for men and women, same word?
Yes, my lord.
Is it?
Yes, ma'am.
Because in
Absolutely correct. Absolutely correct.
Vasanto. Okay. Petitioner has scripted his prayer as attack. Next. Learned counsel for the petitioner vehemently argues that there is a genuine need for verification of the fact as to whether the subject transfer orders were communicated in due course and due time to the petitioner through proper process before concluding the disciplinary proceeding that was commenced while OM number 4385 dated 15/5/2017, the article of charges having been issued on 27/9/2018. Full stop. She also submits that the outcome of verification will cast its shadow or light on the inquiry report dated 28/1/2019, and therefore, depending upon the outcome, there should be reappraisal of the said inquiry report. First time. To accomplish this, she argues, intervention of this court is highly warranted. First of all, learned counsel also apprised the court of earlier rounds of litigations. First of all, next paragraph. Learned AGA appearing for the OPs resists the petition, contending that a slew of petitions filed by the petitioner did not yield much positive result in his favor, semicolon. The prayers are made with the twisted language. Same prayers are made with the twisted language, and therefore this petition is liable to be res judicated. First off. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant a limited indulgence in the matter, in as much as the fact that the verification of the fact as to the due communication of the subject transfer orders will have bearing on the inquiry proceedings, and no prejudice will be caused to the other side if after making such verification, the inquiry report dated 28/1/2019 is re-examined. First off, prayer appears to be innocuous regardless of what happened in the earlier rounds of legal battles. First off, if such prayers are not accorded, the litigants would go home with heavy hearts, and that is not a happy thing to happen in an adjudicatory process at the hands of constitutional court. First off. Next paragraph. In the above circumstances, OP number 3, petition is disposed of, directing OP number 3 to ascertain the factual as to when the subject transfer orders were duly communicated to the petitioner, and on such ascertainment, the inquiry report in question be re-examined for the purpose of accomplishing the disciplinary proceedings in accordance with law. First of all, this to be done within a period of 8 weeks. All right? 8 weeks. First, next paragraph. It is open to the answering OP to solicit any information or document from the side of petitioner, as may be required for accomplishing the task in question. Okay. This part.
My lord, after a period of 1.5 years, they are saying that we have communicated to the petitioner, but he was not at home. He went to the hospital. So it
that will be examined.
I will send along with the order. I will send the brief, means a copy of the brief, so that it will be clear.
Open to the petitioner to submit a comprehensive representation along with vouching material, if any, in support of her contention. All right. Okay.
Thank you, my lord.
Generally, thanks are not said in the court. Get offended. I feel happy. That's another thing.
I'm obliged.
Yes.
My lord, in this case, my lord, the petitioner prays for direction to the opposite parties to give anti-rating promotion, my lord. The similar order already been passed.
The order is passed now.
Yes. Already I have corrected.
Share a copy. You have rectified, you have changed the dates and fact metrics. This folder.
Item 40.
Yes, sir.
Lordship.
Yes.
Lordship, the matter pertains to ragging.
ragging.
My lord, my son who is studying in +3 first year science in Autonomous College Raurkela, Panposh, which comes under the district jurisdiction of District Sundargarh, my lord. In that, the issue relates with he starts from mess management. When my son asked to mess manager why the dal is not provided properly and all these things, it has been asked that it will be rectified. Later on the next 2 to 3 days, he asked so far as the preparation of food is concerned, my lord. Again he asked, as per menu, as per prescribed by the tender and mess management, the menu, as per menu, it is not been provided. So when my son asked, he immediately, one student,
Issue emergent.
My lord, issue notice.
Issue emergent notice.
My lord,
Emergent.
my lord,
Yeah.
my lord, my another prayer, my lord.
Just immediately after service.
My lord.
ETA accepts notice for 1, 2, 3, 4.
4, my lord. Then 6.
Emergent notice. 6 and 7 also.
6, my lord. Autonomous College, my lord.
6, 7, 8 also.
Yes, my lord.
Huh?
Yes, my lord.
No, 6, 7.
7 is the IH, my lord.
Emergent notice to rest of the OPs. Post immediately after service.
Yes, my lord.
My lord. Lord, see me kindly give me date, my lord, because
No,
of
generally.
my lord, happens with me, my lord.
I kindly permit me to argue in your court.
No, my lord, my lord, what my saying? I am practicing Honorable High Court of Chhattisgarh, my lord. I am from Chhattisgarh, my lord. That's why I am taking my lord.
You can argue on
virtual. Yes, my lord. Yes, my lord.
You can argue. You want to personally come and argue here?
My lord, personal pen.
You will call this matter on 22/10?
My lord.
Yes, my lord.
22.
My lord, my interim application has to be considered, my lord.
What is that interim application?
My lord, yesterday afternoon, my lord, one mess manager, he has threatened my son, who is also running the mess, also studying the institutes also, namely Chiku. He has threatened that why you are coming repeatedly objecting these things and that thing, and you come outside and we'll see how we are. This is the threat, my lord.
Petitioner 14% has moved an application supported by affidavit in the open court with leave that some protection, interim protection needs to be granted to his son, who is studying in
Autonomous College Raurkela.
Which is that OP number?
OP number 6, my lord.
OP number 6, my lord.
6 college.
My
lord. He also tells that his minor son is minor son.
No, lord. He is more 19 years old.
But he should have
18 years, my lord. Petition person, I am asking. I moved application. He is running 18 years, my lord.
Running 18. Not completed 18.
No, completed.
His minor son is being put to harassment and ragging, ragging.
My lord.
At the hands of?
Hands of opposite part number 11, 9, 10 and 11.
At the hands of OP numbers 9, 10 and 11.
My lord.
And you gave the police complaint?
My lord, I made complaint also.
And despite lodging of police complaint, nothing has been done in the matter. First time, court has seriously noted the assertion of petitioner party in person, who is none other than father of the student, namely
Vishwamilan Senapati.
For example. First time. This court would take appropriate action at the appropriate stage if the allegations of the petitioner are found to be correct. First on. Come on. Semicolon. This advance warning is sent to OP numbers 9, 10, and 11.
My lord.
This will protect you.
My lord.
All right. Now immediately I cannot pass order.
My lord.
But at least this the text of this order
My lord.
will send some. All. My brother just instruct the police officer.
My lord.
See, they are from
My lord.
other place.
OP number 306, 300, my lord, 307. 307, I need to protect my.
Superintendent of Police, my lord.
Registry to send a copy of this order to OP numbers 3 and
7.
3, 6, and 7
Yes, my lord.
by speed post immediately. All right.
Item 41.
We should teach our children
My lord.
little courage also.
My lord.
Little courage also. Little courage.
My lord.
Maybe we should teach our children martial arts also.
My lord, he is so courageous, my lord. He is so advanced. He is so, he is in a career first class student, my lord. He is having good career. He is not having relations with other students. He is only Lakwita with this. He is not having other relations with other students. He is only having relation with his mother and me. That's all.
Let us see. Let us see. But don't have much anxiety. In almost all colleges.
My lord.
1 second. One second. Please listen to me. Nowadays, we are having only 1 or 2 children. Most of us are having 1 child. So we are having a kind of anxiety as to what would befall my child. Who will do what to my child, etc. That anxiety level should go down. We should have care, caution, responsibility.
My lord, my lord.
Everything all.
My lord.
But overprotective parents
No, my lord.
will make the child more docile and he will not be in a position to tomorrow after he comes out of.
My lord, I never wanted to come before my lord. When I
I'm not finding one. I'm saying this one. I'm not finding this is a general. Yeah.
Please, yeah, the challenge
the lawyer's son is lawyer is also citizen.
Yes, my lord.
Is it not? Merely because he is a lawyer, you can't say that we will not take any action.
No.
Lawyer is also citizen of this country. If lawyer son is also put to difficulty,
He is also officer of the court, my lord. Yes.
no special treatment for lawyers and judges. We are also common people also. That does not mean we should be denied protection.
Yes.
Okay, therefore, keep these words into your mind.
Yes, ma'am.
Do whatever you can do for your colleague. Okay?
Yes, madam.
Okay.
here I am challenging the transfer order. Where
Transfer order.
transfer order, your lordship, number of cases your lordship directed interim protection without violating the guideline, my lords. Minimum retainable period, my lords.
Retention period is how many years? 6 years.
2 years and 6 years. I
Now
am
within
just
2 years you are transferred.
I'm just joined the school, my lord, 4/8/23, man.
4/8/23. But 2 years are over now.
My lord.
Give them.
Then Annexure
Have you
7.
made a representation?
No, my lord. I have given Annexure 7, my lord. Your lordship directed the golden opportunity. The students are backbone of the country. Annexure 7, my lord.
My lord.
Number of cases are in your lordship given the interim protection.
No, you make a representation within 1 week.
Your lordship, number of cases are in covered, my lord.
Covered. But when were you transferred?
And transfer 79 to 25.
79.
My lord.
Issue emergent notice. The AS is requested to accept notice for all OPs.
All impeachment.
All OPs. First. Yes. Next paragraph. An application in IA number. IA number? Serial number
4 months. Given transfer.
But you, IA number 1725 of 2020 supported by a move seeking interim protection.
Lordship issued notice in this case.
Yes.
There is a appeal provision before the Director of Elementary Education. If you will go and
File appeal, but one thing, now you should not disturb him. You are asking him to go to another hospital on a bicycle. He will go, but he should not pull down.
Exactly, man.
Lordship, right. Let's see. You file appeal, I will protect you not to be transferred till then. Basically.
But here the number of cases.
The number of cases we have made this way, that way, depending upon many grounds. Perfect. The short grievance of the petitioner is against the transfer order dated 17/9/2025 at Annexure 3. First, counsel for the petitioner submits that the retention period under the subject guidelines being 6 years, petitioner has just completed 2 years at the place, and therefore he is not liable to be transferred at the whims and fancies of the officials. First, he draws attention of the court to the extant transfer guidelines and tells that they have got force of law. First, next paragraph. Learned AGA, is the G appearing for the OPs, opposes the petition contending that there is a departmental appeal by way of alternate and equal efficacious remedy, and therefore petitioner should be relegated to the same, there being no extraordinary circumstance for the interference of constitutional court. First, there is force insufficient. Next paragraph. In the above circumstances, this petition is disposed of, granting a period of 10 days to the petitioner to file the appeal, if any, against the impugned transfer order. First up, till appeal is heard and decided, the impugned order of transfer, so far as the petitioner is concerned, is kept under suspended animation, coupled with a direction to continue the petitioner in the same place as was before.
Petitioner is concerned.
So far as petitioner is concerned. All contentions of the parties are kept open. Web copy to be acted. Next.
Item 42.
It will be your loss. Yes, sir.
My lord, the petitioner is a scheduled caste lady. Is a scheduled caste lady. She contested the election for the chairperson of Lakhanpur Panchayat Samiti. She was elected.
She was elected.
She was elected.
From scheduled caste constituency.
No, that is a
general constituency. But she is a member of scheduled caste.
The certificate has been granted under Annex 1 at page 10. My lady, your lordship, I will have a glance of it. This is to certify that the Hoteshwari area
belongs to scheduled caste.
It is scheduled caste.
All right, next.
This has been granted, my lord, under the provisions of Odisha caste certificate for SC and ST rules 1980. Well, while I am continuing, previously I was elected twice, my lord, as Jilla Parishad member, as a scheduled caste candidate, and also as Sarpanch as a scheduled caste candidate. That is 2007 and 2012. Well, one Askar Gordia,
he said you do not belong to that.
No, he said that this has been granted by the revenue officer. She made a complaint before the RDC that the revenue officer is not competent to grant this certificate. Further, this Dhibar caste belongs to Chhattisgarh state as well as the Madhya Pradesh state. Therefore, the certificate granted by the revenue inspector, the revenue officer, is illegal, my lord. On the basis of the same.
1 second. After one sentence, this is a complicated issue. You have to stop and then allow the judge to think.
Pardon?
when you make a statement, there should be some comma, full stop, semicolon, because it's not narrating that some novel. Is it not? Because I have to scan everything in the light of what the law is on the point.
This that as per his allegation that Bhaskar Gardia, the certificate granted by revenue officer
is without jurisdiction.
He is not competent to grant. First point.
First point is he is not competent to grant. The second point is in other states he may that cash may be scheduled cash, but not here.
He has been migrated from the state of Chhattisgarh and Madhya Pradesh, where the river caste is there. Therefore, on migration, he can.
A migrant cannot seek such a certificate in the apex court decision, unless that caste is also notified in this state.
Therefore, the RDC sought for the show cause from me under Annex 3, my lord.
Yes.
My humble submission here, my lord, that RDC is not competent to issue show cause to verify my caste, my lord, because the rule provides your lordship, there is an appeal provision that your lordship, that rule is there. Rule 9. Any person agreed by an order passed by the competent authority, subordinate to the district magistrate or collector, may prefer an appeal before district magistrate or collector, my lord. And to the concerned revenue divisional commission, where the original order is passed by the district magistrate, my lord. If the appeal provision is there, my lord, if any person aggrieved, if this Bhaskar Gardia is aggrieved, he can file an appeal before the district magistrate or collector, my lord, under Rule 9 of that Orissa caste certificate for SC and ST rules 1980, my lord. Therefore, the proceeding initiated by the RDC is illegal, my lord, and is not competent to hear this matter. That is my humble solution, my lord.
What is the correct writ which one you should have asked in the writ petition? You are a writ lawyer, yes, of standing. I am asking you, which is the writ you should have asked for?
My writ, actually writ of that proceeding I have prayed for quashing of the under certiorari. I have prayed for quashing of the proceeding, my lord. The appropriate writ is writ of certiorari, my lord. Or Madam your lord to say no.
You have committed two wrongs. If you had said, I do not know, you would have committed no wrong at all. Now you have committed two wrongs. First, the second, this one. The correct writ, D.D. Basu says, when that is quoted by Justice B.L. Hansaria in his writ, which there is writ of prohibition. Because the authority has to be prohibited from holding the
prohibited.
Anyway, that's not important because we have not adopted the English law of writs. We have taken in the nature of writ provision that. Yes, what else?
But,
what is his jurisdiction? The writ of there is appeal. If he is aggrieved, let him go in appeal. Now we'll stay this, we'll send emergent notice. He is also party.
Yes, man.
He's made a, you're made it.
Yes, man.
Issue emergent notice. Learned ASC accepts notice for OP number.
OP number, my lord, 1 and 2.
1 and 2. Emergent notice 3.
Yes.
Next one. An application in IA number 17428 of 2025 supported by affidavit is moved. Seeking stay of subject proceedings till next date of hearing. First, learned counsel appearing for the petitioner submits that there is a appeal provision under Rule 9. Section 9 or Rule 9? Rule 9. Rule 9 of just write down.
Orissa caste certificate. Orissa caste certificate bracketed for SC and ST bracketed. Rules 1980.
Rules 1980. And the said provision begins with the phrase, any person aggrieved. First of there is force in this, prima facie force in this submission. First, a citizen need not be troubled at the hands of officials who do not have jurisdiction for the matter. First, next part, in the above circumstances, the application is favored and the impugned proceedings at the hands of OP number 2 in terms of Annexure 3 are hereby stayed till next date of hearing. Object copy. Yes. Web copy. All copies, interim orders we web post same day. Same day. Even final orders we are web posting. Maybe 1 or 2 days they will. Yeah.
Item 43.
One is submitted the application.
Sorry.
Yes, Mr. Krishna.
Petitioner is a registered society espousing the cause of a downtrodden tribal community called Kondodara. Kondodara people were sometimes they granted scheduled tribe certificate, and they were being appointed in different organizations, and they also taking different courses in education institutions. And thereafter, sometimes shortly happened, they are showing a Telenga. Basing on that, now the cancellations, the authorities have started initiating proceedings for cancellation. My lord, community, the present society, my lord, came before this Hon'Ble Court. My lord, kindly see this Hon'Ble Court bring that there should not be any proceeding basing on the Telenga. And the lordship, the petition also pending, and the lordship also passed an interim order wherein that basing on Telenga you cannot proceed except Madhuri Patil's case. Except following Madhuri Patil case. Madhuri Patil case, you remember that is in 1995
Supreme Court.
1995 Supreme Court. Thereafter, my lord,
Madhuri Patil is the state of Maharashtra.
And thereafter, my lord, subsequently it was referred to larger bench. In larger bench 2012, the Honorable Supreme Court said that yes, Madhuri Patil.
Justice Chawan's judgment. B.S. Chawan's judgment.
My lord, what happened, my lord? Their lordships categorically held that yes, Madhuri Patil case will applicable where there is a vacuum. If there is no rule, if there is a rule, then it will govern according to the rules. So thereafter, my lord, what happened? The petition, basing on that judgment also, again proceeding basing on Madhuri Patil case also, they proceeded for cancellation and all that, claiming that Telenga. But you also can say the society filed a representation before the government that no, we belong to Kondodara scheduled tribe community, and as per the included in the presidential order. So government should make a thorough inquiry and come out with a case that is whether belong to scheduled tribe or not. My lord, may kindly see the government page 56, my lord. For minute or 2-3 paragraphs, page 56. The government came out with a
56.
Well, 56, my lord. My lord, fifth paragraph from top, my lord. Such a community of Western Orissa commonly called who claimed themselves as Kondodara ST represented the government that in these days they are experiencing difficulties in getting caste certificate from the local revenue authorities as belonging to ST Kondodara because of certain local problems, and also of the fact that their community name has been recorded as Telugu, Telengadora, Katriya, etc. And in their land records, acting upon the representation, the institute examined the matter and in order to ethnic status study on this community to see if the community deserve ST status as Kondodara. Let's remember the Madhuri Patil case, that was the direction that ethnic status has to be. The study was conducted in 2 phases during 2008-9, and the first phase 11 villages under 4 blocks of Bargarh district and 4 villages under 4 blocks of Balangir district having larger concentration of Kondodara in Western Orissa were covered to compare the socio-cultural data of Kondodara of Western Orissa with the Kondodara of Southern Orissa. The second phase study was conducted in 6 villages under 4 blocks of Koraput district where the Kondodara are found in large concentration
in the border areas of Orissa and Andhra Pradesh. The study findings have been presented analytically and comparatively in the report called titled Ethnic Status and Dora Public Condodora Community. Then you'll also kindly see last part one para. So far as their socio-cultural feature are concerned, the Dora Oblique Condodora of Western Orissa bear many similarities with the Condodora of Southern Orissa, especially in respect of their traditional mother tongue, housing pattern, clan system, birth, poverty, marriage, divorce, and death customs, magical religious beliefs and practices, deities, rituals, and festivals, socio-political system, as well as their social ranking in the local community hierarchy, in which they are treated at par with the mother tribe, in both areas. Yet the Dora, Oblique Condodora of Western Orissa, last paragraph. Thus, as per our study, the people of Dora title, that is the so-called Dora people of our study area, the Bargat and Balangir districts in Western Orissa and Koraput district in Southern Orissa are found to be Condodora. Regarding the ethnic status, the so-called Dora of the other districts, these findings may not be generalized because they are clearly indicated. But among them, only last among them, only those who possess the social. So we are concerned with Western Orissa because the Western district like Balangir, Bargat, etc. What happened, my lord? This report, because there is particular people, some particular communities, they were challenging, they were after us. They were initiating all these proceedings before the authorities. My lord, they filed writ application for this Honorable Court, challenging this report. This report, my lord, the government filed a counter defending the report and say that this report is final and binding and the action should be taken as well. And ultimately, when the lordships were not inclined in favor of the petitioner dismissed it. So petitioner reviewed the petition got dismissed. But thereafter also.
Very same petitioners.
No,
different people.
The petitioner who had challenged
of your association.
They were challenging our status as Condodora state, they're challenging our status. So they had filed writ application. The government relied on this report, defended the report and said that this report is final and binding. So accordingly, they filed a counter.
You are now before the court in your capacity as association. Which right of the association is affected?
Well, association, because our community, our members are.
Then PIL.
Well, it will not be PIL, my lord, because it is a particular community.
No.
PIL will be public at large.
Individual, because individual grievances are covered under the Act.
Individual grievances are covered there.
The interest of whole community. What is your right?
My lord,
you are only association.
Yes, I am the association, but most of the members of the association are. Most of the members.
The judgment of apex.
Yeah, the
association cannot maintain a writ petition unless its own rights are affected.
Yes.
The right is not affected. If the association status is taken out, if association's registration is cancelled, if association's elections are upset, then you will have right. Association will expose the cause of
but I'll also kindly give me 1 or 2 days time, my lord. I'll find the association can also expose the cause of it.
The latest judgment of apex court.
I'll find out.
Learned senior advocate Mishra argued at length, first off. Then, as to the maintainability of the writ petition by the association for espousing the individual rights of its members. First,
sufferings caused to the members.
When this court expressed its view as to non-maintainability of petition of the kind, he seeks time to come back with more study. First, call this matter after vacation before this bench for further hearing.
My lord. Obliged. I love you.
Yeah. Yes.
Pardon to mention, item 161 of weekly list, kindly taken tomorrow or day after tomorrow. Because the urgency is petitioner is not receiving his salary after rendering 32 years of service. So he is not being paid for 7 to 8 months of
The
time.
preceding 7 to 8 months.
Yes. He is not. And his retirement is on this year.
Can we have it immediately after vacation? Some date I will fix.
If
15 in the regularization. Dot.
Item
Yes.
my lord, I am there, I know the instruction.
Pastor Matt is there. Item 1. Sorry, item 2.
Item 2, my lord.
Yes.
I have got the instruction. I am sending a copy to my senior. No, please. Proprietor upon level. That is your entitlement. That I cannot dare to. My lord, it is written that with reference to the subject cited above, I am to say that the boy
Completed and handed over since 23 years back.
3 years back.
It has become
Must have done that after vacation of stay.
Yeah.
Your lordship wanted to see probably, but it was.
I wanted to assert.
Now it is being used by the community in times of disaster.
Learned AGA appearing for the appellant petitioner.
For the opposite party.
No, in your OJC is what is that?
What is that? That is petitioner opposite party. Petitioner is
The opposite party before the deputy district collector.
no. We are there for the opposite.
You are the
party.
petitioners.
No. He's my
I'm for the
senior.
petitioner, he's for the opposite party. So
Opposite
state
party.
opposite party.
Okay. Learned senior advocate appearing for the petitioners very fairly submits that whether we should make it your submission, I will make him his submission that
Yes.
you will not controvert
Exactly.
that. Recall that. Learned AGA appearing for the opposite parties submits that this petition, is it petition? Petition has become infructuous in the light of completion of the cyclone shelter structures more than 23 years ago. And therefore the same be accordingly disposed of. First of all. He has also placed on record a copy of block development officer, a copy of letter dated 24/9, letter number 3364, dated 24/9/2025, issued by the block development officer Mahakalapara to his office, which reads as under. Next paragraph. Learned senior advocate appearing for the petitioners does not, will say, is not in a position to dispute, is not in a position to say anything on the contents of the said letter, since matter is very old, and he could not immediately establish contact or conference with his clients. First, next paragraph. In the above circumstances, no purpose would be served by keeping the matter pending just to languish in the court cupboard for years to come again. First off, in the above circumstances, petition is disposed of as having become infructuous, reserving liberty to the petitioners to seek its revival by moving an appropriate application if the contents of the subject letter referred to above are not true and correct. That is the purpose. Yeah.
That's all.
OJC means original jurisdiction case.
Yes.
The nomenclature was OJC that has been changed to WPC.
Perhaps this is the last, this is the relic of OJC now.
Yes, yes.
Okay? Item 22? Yes.
The petitioners are the headmaster and secretary of managing committee of Gothana High School under District Education Officer Keunjor. Your Lordship, kindly see the informed order, my lord.
They want to take examination.
My lord.
When the examinations are scheduled?
February, my lord.
February.
February.
Let notice go.
Well, they allowed the form fill up as a regular candidate. They were not allowing. They were treating the quasi-regular candidate. Your Lordship, kindly see Annex 16, page 43.
Quasi-regular candidate. Contract, I have heard. Quasi-judicial, I have heard.
Your Lordship, kindly see page 43.
Yes.
Recognition has been granted. Board of Secondary Education, Odisha, page 43, my lord.
School is de-recognized.
No, till yet not de-recognized. Your Lordship, kindly see. They are saying that school has been de-recognized. Your Lordship, kindly see. Annex of 13, my lord. No order, Annex of 13, page 38. Even though director issued letter, the secretary and headmaster appeared, but no communication was made after 23/12/22. I appeared on 13, date was 31/12/22. Thereafter, hearing was made, but no order was communicated. Thereafter, 2 directors changed, my lord.
When institution is de-recognized?
Has not yet been de-recognized.
It is not de-recognized.
By the competent authority director.
Yes, Mr. G, merely because proceedings are going on.
My lord.
What is that? He says that the institution is de-recognized.
You can see the board letter. De-recognized. Only de-recognition shall be made by the prescribed authority, means director.
Annexure 16, Lordship, kindly, page 43.
16?
Yes. It is a letter from the Board of Secondary Education, Odisha, which is impugned before your Lordship.
Correct, but it is saying de-recognized. Where is the de-recognition?
That letter referring Annexure 16, that is 39/22. After 39/22, letter was issued.
Appearance.
No
order has been.
No, in December. No order has been passed.
Till date, no
order has been passed.
Yes, how can board assume that it is de-recognized? It's a very serious consequence.
Board must have some communications.
No, it has referred to communication.
Yes.
2020.
Yes.
Beyond that, it has not referred to anything.
I do not know, my lord. I have no instruction even.
Therefore, previously, petitioner institution came, and this director interim order for that session, and interim order will also kindly see on the basis of said interim order, they allowed as a regular candidate.
Now, you should be permitted to what?
To appear as a regular candidate.
To appear as regular candidate.
Unless I got instruction.
In 2025 also appear regular candidate.
All right. We will call this matter on reopening day. We'll issue notice and let them say.
Yes.
Till then, they will accept the form fill up, my lord.
Which is the last date for filing of forms?
For I am submitted the report, but on the basis of the input order, they are not accepting. On the basis of
direct, we shall allow them to form fill up.
Regular candidate form fill up.
But after that, my lord, after getting instruction, I do not know what is
subject to outcome. Let them fill up the
forms as a regular candidate.
Forms probably, my lord, not yet started.
Already started, my lord.
Started? When did it start?
No, Lordship, kindly see, they have intimated me.
Issued emergent notice.
Annexure 5, my lord, kindly see.
AGA Mr. G requested to accept notice for the OPs, all OPs.
Well, except board.
3, emergent notice to 4. Next paragraph. An application is moved in year number so and so supported by affidavit seeking reprieve at the hands of this court. First off, counsel submits that the impugned order of the board is without any basis in as much as it refers to a particular proceeding which is only an intimation for appearance of the parties and not the order of the recognition. And therefore, as of now, there is no effective de-recognition of the institution at all. First off, he further submits that even in the last round of litigation, that was the inarticulate premise. What happened to that case?
That case, your page 39, your lordship's order. This honorable court order directed to, as a regular candidate, they allowed me. Page 40.
And that is in WP number
26023 of 22.
26023 of 2022. A coordinate bench of this court. Why the order dated?
Order dated, my lord. Order dated 19/10/22.
That matter is still pending.
No, disposal of my lord. Because of that session, they have
By the interim order dated 19/10/2022. Where is the interim release? 22. The petitioner institution was permitted to accept as many as 28 students to appear as regular students and therefore work students. First up, in all fairness, he submits that the said petition was disposed of as having become infructuous after all the students appeared in the examination. First up. Next part. In the above circumstances, the application having been favored, the students are permitted to appear as a regular candidates in the ensuing examination at the petitioner institution. Okay? Subject to further orders. Yes. If any further orders, revocation, modification, you move that, we will consider.
Yes.
Okay. This protection is granted keeping in view the paramount interest of the students, than that of the institution.
Lordship, when the matter will be listed?
Call this matter on 28. 28.
Item 44. May I please, Your Lordship? Petitioner is a retired clerk and due to superannuation in the year 2018, on several occasions he moved pillar to post for some reason or other. This honorable court passed a rigid order and not dismissed any case. But unfortunately, Annexure 10, the OP number 2, challenged this honorable court and also insulted the petitioner. By saying the version, I will come to that.
Now, what's your prayer, brother?
To question that
the silencing the court, silencing the lawyers, and raising the decibels. These happen in court halls, in school, in theaters, in drama theaters, everywhere it happens.
How they are daring to
see your prayer.
Yes. But let us first I come to Annexure 8.
Read your prayer first. In the light of that, we will understand the pleadings.
The petitioner therefore most respectfully humbly prays that this honorable court may graciously be pleased to issue rule list to the opposite parties to file show cause as to why the writ petition shall not be allowed, and failing insufficient cause make the rule absolute. More particularly, opposite party number 2 for his illegal and unconstitutional statement shall be punished and liable to be pay compensation at the tune of 10 lakhs to defame the petitioner as well as this honorable court.
I may draw your attention, my lord. The unconstitutional statement he did.
Yes,
One thing I should tell you.
yes. I will say, I will come.
One thing, but because many students are there.
Yes,
In United States of America,
yes.
they burnt copy of the Constitution and they were prosecuted. Court said it is a right to expression. Unless law is there, nothing is unconstitutional. Just by burning the Constitution, the provisions of the Constitution will not be available. Anyway, what is the statement?
Right to expression is other thing.
Show your sentence.
When I come to Annexure 8, the order passed in WPC 23495 of 22, that at page 36, the order portion as 40, the Honorable Court consider the grievance of the petitioner on 2 months.
Yes. You have said the page number.
Page number 40.
Allow the judge to read it.
Yes, page number 40. Page number 40. Dispose of the writ petition.
1 second.
Yes.
Order by brother judge.
Yes, my lord. 2 months has been granted to consider the representation to dispose of. The order was passed in 17/3/2023.
1 second. Slowly.
Yes, yes, my lord.
17/3/2023.
2023. As the same has not been complied with, come to the Annexure 9. Contempt petition was filed by number 5066 of 2023. The order was passed another 1 month. First contempt, second contempt, you will no, contempt is always contempt. 1 month was granted. Order portion is at page 44.
44.
Page 44.
Individual litigant having
No. That is another part. I will come to that aspect.
No, you said I was reading them.
Yes.
If you inject me from reading, I will not read at all.
No. But 1 month time has been passed in the contempt petition as page 42, paragraph 4. 1 month time. Thereafter, your lordship may read the last paragraph, that the petitioner is habitual litigant having filed several unsustainable cases in different rounds in the past with imaginary claims and assumption on what rules should be instead for raising issues on what rules actually are. The instant there is thus baseless, dwells on imaginary reasons and lacks doubtful merit. The prayer is therefore rejected. The order dated 17/3/23 passed in WPC number 23495 of 2022 is hereby complied. If 1 month time was granted to compliance, but this order is passed on 29/4/2024 after 8 months. And the
1 second. You have to make statement and you should have make use of the symbols, full stop, comma, make best use of them.
Yes, my lord.
17/3/23 order was made. It had granted 1 month or 3 months?
2 months.
2 months.
Thereafter contempt. 1 month, another 1 month granted. Order was passed on 31st July 2023. Contempt.
All right. Thereafter, this is 9/4/24.
Yes, 29/4/2024.
29.
The Annexure 10.
24. This says imaginary claim, etc.
Yes. Who is he?
No, I am asking you. I do not know who is he actually. Appears to be Director Secondary Education.
The court is holding a constitutional post. Therefore, I am saying that he is using unconstitutional word. How tall he is and how dare to speak such like. It is a contemptuous.
He should not have done that arguably. Let us see their objection also. Yes, brother, what is...
Lord, the petitioner claimed for unutilized leave salary, my lord.
What was his claim before the court, earlier court?
Lord, That is related with pensioner benefits, my lord.
Pensionary benefit. He wanted pensionary
Other
benefit.
pensioner benefits has been granted, my lord.
Granted.
Which is presently claimed, my lord. That is not admissible under law, my lord.
No, he is saying.
Unutilized leave of 365 days, my lord.
Huh?
Unutilized leave, as per his...
Encashment of surrender leave. Encashment of leave.
Yes.
Leave salary, na?
Yes.
What
Yes,
do you
my
call it in your state? Surrender leave or encashment of leave?
Unutilized. Unutilized.
Yes, you surrender it and you get the money, the wages for that.
In other words, on surrender leave?
Surrender leave. That surrender leave,
They have not granted.
Has it not granted?
Not granted. My point is not that. My point is the such language that insulted the petitioner.
No, well, it's all right. We'll go to language thereafter. First, let us see law. What is your grievance? What you want? Now, surrender leave is granted to you.
No, not granted.
Leave benefit is not granted.
Not granted.
You don't want surrender leave benefit.
Yes, I want.
But you are not prayed. You only say he has made unconstitutional statements. Take action.
In this case, I want compensation because of because they have damages to the prestige of the court and the prestige of the.
And then only 10 lakhs. Prestige of the court is only 10 lakhs.
If your lordship please to impose some other, I have nothing to say.
In your estimation, prestige of the court is rupees 10 lakh will do that.
10 lakhs because of the director is concerned.
Okay. What do you say about that? He wants 10 lakh rupees from your director. 2025 matter.
2025.
You have not filed objections.
First time.
You filed objection. You filed.
No, we have not filed. First time.
First time it has. Learned ASC is requested to accept notice for all OPs.
All OPs.
Yes, all OPs. Next.
Item 45.
May I please your lordship? I am appearing for petitioner.
You are appearing for petitioner.
Yes, your lordship.
What's your prayer?
My prayer is
Disperse admitted dues.
yes, your lordship.
Within them. Where have they admitted the dues are so much?
Kindly say para 4, your lordship, page 3.
Para 4, page 3. That's your petition.
Yes, your lordship.
Where have they admitted that so much is due and that is true? We have that money, we are liable to pay, but we will not pay. That admission.
Annexure 1, kindly say annexure 1, your lordship. Pending before OP number 2.
That is your letter. Is it your letter?
Yes.
Annexure 1 is what?
Page 8, your lordship.
Yeah, I have seen that. Date is 28/5/2024.
Yes, your lordship.
Read that. What is that? Inviting reference to caption subject. We are enclosing here some relevant documents for your kind reference. Since the payment is long outstanding, we bring an MSNE. We are in urgent need of funds. We therefore request you to kindly help us in releasing the outstanding dues. Where have they admitted your dues? If that representation is considered
Annexure 2.
Annexure 2.
We should forwarding letter, madam. We also forwarding letter.
It's a direct letter. Reference subject to submit and directed to request you to submit the action taken report regarding payment. Yes, outstanding payments are there. Why you want to retain that money?
That instruction not there, madam. I have taken instruction, madam.
He is requested to accept notice. Yes, he is requested to accept notice for OPs. First up, since the matter lies in a very narrow compass, call this on 27th. What's your name?
Arpita Parida.
Heard. Learned counsel Miss Arpita. Mrs. Arpita Parida, who argued very well. Issue emergent notice. ASC requested to accept notice on this narrow compass. Call on 27th.
Obliged, Your Lordship.
Very good.
Madam, what is your lordship? My lord, this petitioner is a 76-year-old man who is fighting his case relating to unauthorized construction in his building since the year 2000. This is the third round of litigation, my lord. I am here challenging the appellate court orders passed by the Secretary HMUD on the basis that it has not followed. It is a completely unreasonable order and has not followed previous two orders of this honorable court.
So will issue notice now?
My lord.
Issue emergent notice. Learned ASU for 1.
For 1 month.
Emergent notice to 2 and 3. Yes. Post immediately after.
My lord, I pray for an interim order, my lord. I have an interim order. My lord, stay of this order, my lord. I pray.
No, that your appeal is dismissed.
Appeal is dismissed, my lord.
Dismissed or dismissal order be stayed.
Yes, my lord. Why they have said, why I am asking for stay, my lord? They may direct for demolition of the building, my lord. That is the only thing. My lord, because the case is, they say there is no setback. In 1988, my ground floor and first.
Did you have an interim order at the hands of the appellate court?
No, my lord. Before this High Court, before this honorable court, my lord, I had.
In the earlier round of petitions?
Earlier round of petitions, my lord.
We'll say status quo till next date of.
Yes, my lord.
Status quo till next date of hearing. First off, by a number so and so will be considered after appearance of opposite parties. Okay.
Item 48. May I please, nurse?
Yes, sir.
Here is a case, my lord, case of transfer. Virtually, in the guise of transfer, I have been sent for deputation 5 times. And one institution I am directed to continue, and other institution I have to work for sometime in 2 weeks, sometime in 3 weeks. Just I am netting the facts, which are the dates I have it.
What is the difference?
Within 5 months, 6 months, 1 month, like
I am asking. I have not put the question at all.
Oh, sorry.
You appear to be
I was
everything that lurks in the
I was
heart of the
rushing.
judge.
Another put, yes.
I am asking you, what is the legal concept of transfer?
There is
And what is the difference between transfer and deputation?
Yes, ma'am.
Which decision discussed this aspect of the matter?
Decision of court I can speak, my lord, but so far the deputation is concerned, so far the government employee is concerned, the Orissa Service Code takes care of that.
What is?
That says, my lord, an employee can be sent for transfer to one department to another. But this is here, there is no such rule for transfer and deputation.
Applying it to your.
Yes.
So in my court, many youngsters sit. Their professors advise me to have engaged good lawyers in debate so that they will learn law. I will tell you. Samaraditya Pal on law relating to public service has discussed this under the chapter transfer. He has referred to Justice T.A. Desai's, as his lordship then was, judgment of Gujarat High Court. Ask the librarian to bring Samaraditya Pal, law relating to public service. He says the difference between transfer and deputation is, in the case of deputation, there is the parent department, transferee department, and deputationist. Number 1. Number 2, the consensus among these 3 units is the bedrock of idea of deputation. In the case of transfer, he says it's the prerogative of the employer. He also quotes a famous judgment, State of Karnataka versus Varadhara versus State of Karnataka. Yeah. In which idea? Could you get that judgment of Justice T.A. Desai?
Yes, ma'am. Just
Can anybody just Google out that judgment from your Google library? Justice Rama Joyce, in his services under the state, also has dedicated a few paragraphs on this. Yes. In which parameter your case fits?
Dr. Shripad Desai, the one is there, my lord, just I have not read it. The plus time I am having it.
No,
reading
Justice
it. This is
T.A.
from
Desai.
Kannada. Yes, Justice T.A. Desai's husband.
Not P.A. Desai. There is another Desai. D.A. Desai.
D.A. Desai.
Judgment, the judge of Supreme Court.
Yes, my lord. That
D.A.
is,
Desai, sir. Keep standard books, service law.
that is one of the case of Karnataka High Court. Dr. Shripad Desai versus State of Karnataka. There is a case of transfer.
Yeah.
That only hold that the transfer is a prerogative of the
State.
authorities. That is there. Another judgment of Justice Desai is dissented. Union of India versus Sankal Chand Himatlal Sect. As it is coming from Google only, I am reading. Well, I have no offhand knowledge. So,
in fact, Samraditya Pal is one of the best books on law
yes,
related
I
to
have
public service.
exactly that part.
Yeah.
I cannot.
In the very chapter, the first paragraph, well, he mentions that judgment. Anyway, now you are bringing your case into which parameter? Because consequences will be different.
My difficulty here is just I'm telling the two to three dates.
Yeah.
I've given a note also, but I prepared one for my lord. Only these dates may kindly be seen. I have summarized the dates.
Give you.
Just
Joining is February 2006.
that is my lord, my service career habitat. 2/11/19, while I was in one Hasanpur High School, I was transferred to Bonavui High School. There you also have no grievance. I joined there. 2011-19, after 18 days in joining, I was sent on deputation. This is my misery starts from 2019, madam.
No, my misery is why do you call it as deputation?
They have written it deputation. That is the
They
problem.
may write 100 things. As a lawyer, I
Yes.
should ascertain whether they may say very unconstitutional statement. That's
Yes,
the other case
yes.
you have seen now.
My lord, my response submission is this cannot be a deputation because I am within the same department. I am not different to a foreign service staff as per the Odisha Service Code. Man. That is my submission. Kindly see, my lord. Just I am placing the facts. After 18 days, I was deputation to the Nidhipada Sevashram. This was, there I have also worked. While I was there, my lord, on 4/5/22, I was again sent on deputation to Deula Ashram School. Instead of transferring me, they said deputation. I joined there. 25/1/22. Sorry, that will be typo, Mr. Madam. That will be 23, my lord. Sorry, these are the two type mistakes. 23.
22/3/23, 9/10/23, 12/10/24.
My lord, I have given, my lord. That will be 25. I may stand corrected. 25/1/23.
25/1/23.
Yes, madam.
Instead of 22,
22, it will be 23, madam.
21.
25/1/23. Just after 6 months, again, I was sent on deputation to work in another school at Srikona for 3 days in a week. That means, my lord, out of 6 days, I am to work 3 days in Deula and 3 days in that other school, which is about 20 kilometers away from the main institution.
The first time matter has come up.
No, it has come, notice has gone. I have written everything.
I want to know.
Pardon, madam?
Whether first time matter has
No. After
notice.
Yes. It is there, madam. What record it is?
Mr. G. Why you are easy, such a most brilliant teacher who is sought after in every school?
My lord, probably they want their service in every school.
3 days in a school, another.
Students should avail their prudence, my lord. Good teacher.
The counter is otherwise, madam. Counter is otherwise. I'll say.
No, sarcastically he is saying.
Yes, wait.
Counter is not there.
You got to
Counter is fine now.
Yes, fine. I'll look. My lord, can you say the dates on? Thereafter, I'll place, madam.
Now you are working there.
No, my lord, my difficulty started further again.
Now what is it?
Just I'm placing this 2 pages only. I'll place.
No, I'm asking you.
Yes, what happened, my lord?
Only 2 days court is working. Very important.
No, if my lord allow me, I can 2 lines I will complete. My lord, these 5 institutions I was directed to work in 2 days, 3 days. Thereafter, I was before this honorable court in a writ petition because this was painful for me.
in the writ petition, it was disposed of on 5/12/24. The last order was on 12/11/24. Again, another order of transfer. So I came before this honorable court. Then honorable court has said, you go and approach the state government because the collector is doing all this record transfer. Yes. You go and approach the state government. I have, and thereafter, my lord, have directed that till the state government take a decision in the matter, that I will be continuing that place. Correct. So, but when the matter was pending with the collector, state government, by the order of this honorable court, again that collector passed an order of transfer on 4/2/25. And the government passed an order by justifying that collector's order only after on 25/2/25. Now it is up. In which school you are working? Now I am not working because that transfer order I could not join. I came before this honorable.
Senior advocate Paddy, Mr. Paddy is leaving the court now. Since you went on arguing the matter.
Personal to them. He will have it stop.
Take out deputation.
Now I am not, because that transport I have challenged against this writ petition. The honorable court has only issued a notice in the matter. And in the meantime, when the notice has been served upon them, now they have placed me under suspension.
Yes, Mr. G. Why are you troubling him when the festival is coming shortly?
My lord.
Yeah.
I'll not speak some more, my lord. Lordship may kindly have a look to my counter annexure KY3. Joint inquiry of district welfare officer and welfare extension officer Balasur Sadar against headmaster and lady assistant hostel superintendent of Hasanpur Assam School. Lordship got it, my lord?
Yes.
After getting a phone call from Headmaster Hasanpur Ashram School at about 7 a.m. regarding locking of the school gate by the students of the said school, I, along with WEO, Sadar, immediately rushed to the spot.
Mr. Dash, just see this. Yes, page 138.2. So beautifully that lawyer has he's a husband of Justice Huma Khan.
Yes, I got this
very volume body here. I like it, the way he has placed the difference between transfer and deputation. So articulatedly. Kindly read it loudly. It makes a tempting reading.
The concept of deputation in the law relating to public service.
No, right hand side.
It is a distance between the transfer. Yes, the distinction between deputation and transfer. The concept of deputation becomes clearer after considering a difference with the transfer. It would, however, suffice the movement to extent of the following observation of D.A. Desai J. While sitting single within the Gujarat High Court. Deputation and transfer basically differ from each other in that transfer can be only to an equivalent post in the same cadre. Deputation must be in department other than the parent department, where even equivalency may not have been determined. Transfer is the right of the master, and it is an incident of service and can only be challenged on the ground of malafide or violation of statutory rules relating to transfer. Deputation can only be with the context of because of employee joint department to render service in that department, and he cannot be made to serve somewhere else, maybe in a post much lower to his post. This is the so my case is here, my lord.
Anyway, now we are asking. There is something more to that case.
Yes, that is with regard to the fact that
matter requires consideration.
But kindly see my misery, my lord.
Nothing will happen. You are paid the subsistence allowance. You will enjoy.
Now, my lord, the proceeding. No. Now they will proceed further. That contemplated proceeding against me. Suppose anything will happen, my lord, then.
What will happen? Have they issued that?
Yes, the so-called it has been posted. He has not received yesterday. Till yesterday, it has been posted in his knowledge.
Posted.
That is from the office.
You reply to that now. In the meanwhile, we'll call this matter reopening day.
Yes, my lord.
Matter requires consideration. We are in the paucity of time because There are many cases are coming. Only 2 days court is working. Yes. Call on 8. How many cases are posted?
28 cases.
28 on 9.
17 cases.
17. And put it on 9. Yes.
Item 49. My lord, I have filed it is listed for orders. I have filed the interim application that the Berhampur Municipal Corporation is violating the interim order passed by this honorable court, that order of status quo. The case is that, my lord, the petitioner is the owner of the land and the Berhampur Municipal Corporation forcibly entered to the land and making construction over my land, my lord, my private land.
My lord, I am appearing for the corporation, my lord. I received the copy of the IA only yesterday.
Yesterday.
My lord. So your lordship may call it on 8th. I will take instruction in the
9th will call.
My lord.
8th it is more burden. 9th you can call. 9th.
9th, my lord, the interim order may kindly be extended, my lord.
Interim order to
Status quo is there, it will continue. My lord.
yeah. Interim order to continue. Then we will call this matter on 16th.
My lord.
Interim protection is there now. If they violate, then we'll take action.
They have.
You will get the building also.
Yes, my lord.
Along with the building, you will get back the property.
My lord, because the case could not be listed, I have assured the client that you will get everything.
Everything means including building.
Including building.
He will be very happy. Wait. Call on 16th. How many cases are posted on 16th? 12. Yes. Put that on 16th.
Interim
Your client. Not to violate the interim orders or final orders of the court. That's not a good thing to happen.
And in my land.
I will file a detailed counter.
That is where the order operates. Yes.
Next date, my lord.
Yes. Interim order continue. Shri. Right. So appear upon copy number. Yes.
Item 50.
May I please? 50.
As of 50, I find from the noting that the OPS filed an application for seeking time, but he has not been appearing. Here we have annex 4, page 15.
What's the urgency? 2021 matter.
Specific date may can be fixed.
Number 17? Old matter. 7? Okay. Yes. Good.
The interim order was there, that may be extended.
If interim order continues, then it will be called in November. Interim order to continue, call it first week of November.
Item 51.
51.
Now, your lordship say, I have already received the counter copy from the OP, that may can be.
You have received the counter copy?
Just now received it.
All right. Counsel for the petitioner has received the counter, copy of the counter filed by OP number
125.
125.
Two of the elements.
Yes.
Item 51.
Yes.
For the opposite service.
Anyway,
Means I don't have an objection, but fact remains these people, the opposite party who has become the selected bidder has deposited 80 lakhs.
Entire amount, 80 lakhs or. But their provisional allotment has been made in favor of me. Since matter is pending for this honorable, they are not giving the position.
No, that is the interim direction.
Exactly, considering the my lord sir other day has passed this order on 31/7/2025.
no, 20 August 25.
They explore the possibility of amicable settlement.
That has not happened.
Because already I have got the larger plot.
Who is the petitioner?
Petitioner Mr. Kanungo was appearing. Last at my lord's argued that.
Maybe that he knew my mind that I will not take up this matter today.
Oh, maybe so.
Darling, first week of
My new opening is happening.
You are in possession of the property.
No, I have
Not yet granted.
They have not been possession. We have been made in mind.
First week, we will do that. First week of November. Yes.
Item 52.
Well, sit first.
The conducting council name is not reflecting. That may be the
Name
cause.
is not reflected.
No.
Registry to print the name.
case Kanungo was like
Nanta nahi boli bodhe.
no, Mr. Mahanti's name is there. On behalf of Mr. Mahanti, Mr. Kanungo applied.
Number of occasions.
I will print his name also.
I will.
Print. His name is there. The name is there.
But in the cause list is not.
In cause list it is not printed. So print
Cause
that.
list is not there.
Registry to print.
Yes, can.
We have some difficulty. Otherwise, I would have taken the matter. Yes.
Item 52.
Yes.
In an identical matter, your lordship decided the issue.
What I pray before your lordship is, if your lordship goes one by one, it would be better.
It becomes easy.
Emails, may I submit matters one thing? With, of course, with due leave. This matter matters already passed an order relating to regularization. This can be split up. Let's make a few cases that can be covered by that decision.
Which are covered by the judges.
I have 6 number of cases.
6 number of cases.
Yes, I have.
Patnaik is whether they are covered. Those matters will dispose of, then take one by one.
No, let us be better to take one by one.
You have given
I have
these
also,
matters are covered.
Yes, also serial number also there.
They have changed it.
Yes, corrected. First 5 cases.
First cases.
Yes.
The dates and other things, everything you have changed.
Yes.
Which one? What case?
We can dispose of these 5 cases. Yeah.
5 cases.
Next 3 matters.
1 second. 1 second. Slowly. WPC 23917 is over.
Yes.
WPC 23857 is over.
Yes.
23860.
Yes, madam.
Covered.
Yes.
23865.
Yes, sir.
2386 That class 4 employee.
Yes.
23920.
That in serial number, last but third. Last but third.
WPC 23191. No.
23920 is the same also.
23920.
Yes. That's supposed for 23920.
Yes. All right. Okay.
And another one, the last but 3.
229. All right. Yes.
And another one, last but 3. 237259 of 23.
You got it now? All right. Now let us start. Now your work is over. You yield place to your friends.
Yes.
Oh.
No, the matters also is relating to your DTC. But what I pray for your lordship, these DTC matters be separated and taken up on some other day, so that whatever we have, we can place before your lordship.
My lord, it is also covered by the Litun Pradhan judgment.
That's also covered. Show it to Patnaik first.
That is,
you want to go through?
Yes, madam.
We will call this matter on 10th. You said minimum 9th or 10th? One matter. We call this matter on 10th. All right.
My lord, kindly take some tomorrow.
Tomorrow only. So much urgency. Many heavens are falling down.
There is possibility of change of assignment. That's why I want to.
You have multi reformation done.
The question is that my lord, judgment is there. Judgment will always be.
All judges are far better than me. Perhaps you have not tapped their goodness. Yes.
Item 53.
My lord, next sub-item, I permitted to file and rejoinder. That is WPC number 321.
You file. I am calling it now, na? Okay. There you have to seek your rejoinder is leave of the court. Is it not? Leave is sought for filing the rejoinder. That way you have to write that.
My lord, next sub-item 32263. Namely, Padmanabha Parikh is coming under the judgment of Ananta Chandra.
Which your lordship has just. Which is that? Give that judgment and change all the details which your friend has done. So that you change and you give that comment.
I will change it and during course of that I say
give that. Okay. Do you want one copy with you for the model?
Copy. Yeah.
You have copy? No. I have that. Yes. How you should change? You ask your friend here. Changes that changes representation dated, date of entry, date of regularization. This that it's representation. Okay, which is that? WP
32263.
All right. You have noted.
And next item 34068.
Using the judgments now.
My lord,
You are same now.
No, my lord. That is the covered by the same Ananta Chandra Naik, and I submit during the course of the day.
My lords wanted that you get a copy, correct it and give it to them so that they can.
I submit during the course of the day.
Yes. Very good. If you submit, we will dispose of that also.
My lord, this sub-item 488/23. Interim order may be continued. Counter has been filed. Copy not served.
Wherever there is interim order, the same to continue.
Counter filed, copy not served.
It is in between the lawyers.
Yes. Next.
Open 53.
Right. Well, item 53. Today I'm filing the appearance of the senior.
Started first week of November. Okay. Next.
Item 54.
54, my lord, this is the client is fighting out litigation.
He is only before minor after retirement for arrear salary for a particular period for which he was illegally prevented.
Nice to continue in that case.
Yeah. Whenever there is interim order,
Initially, the petition was terminated. A person was appointed in his place.
That's any urgency, or we can take this after. But I feel bench may not be changed.
Really, here's a case. It is a here my own expectation always is.
The lawsuits have raised this, but actually lawyers this side have a great anxiety of these changes of bench. I'll tell you lawsuits what. But one matter was heard in a bench 4 days thereafter because of the new system. Roster changes. If the roster changes, no concept of part-head, it goes to another bench, and it starts de novo. Then
and again, same thing will continue.
Third bench. Sometimes, it's quite painful for the clients.
Pending with Barre.
No, what I humbly submit, we are no one to say, but the rules should be that it should not be changed even if the roster is changed or the part-head matters at least. Unless the
part-head matters.
No, it changes in our High Court. Yes.
2012.
Earlier it was confined to that judge only.
Okay.
But subsequently it was changed.
High Court rules has amended.
There is no concept of part-head.
Even if it is part-head, that is difficult for the
Exercise will be fit.
entire exercise. In big matters, hard for fates. And it starts, then goes to new bench. Unless
Rest of time.
Yes. Rest of time with the court also. The Honorable Chief Justice is the master of rosters. He can always change if you want. But that's a different matter.
That's true. I understand that. Yes.
I'm just submitting a list of dates. Because this case, the prayer is only for the arrear salary. Case up to and went up to Honorable Supreme Court.
We'll take it on 10th.
Yes, ma'am. I'm just giving it. Take on record.
Take. Yes.
I'm giving a copy to my.
Court so much to adjourn the matter to 10th. Yes. Yes.
Item 55?
Yes. Lord.
Yes.
Following your lordship's advice and pattern, my lord,
Yes.
I am absolutely ready and I am absolutely keen that the matter will be heard. But I was given to understand from the State Council that he got the brief at 10:45 in the morning. So he is not ready. So I would not like to waste your lordship's time. Though I am very keen that a matter be heard. So just and there is an urgency also to a certain extent. Urgency means not an interim because I have so lordship may just after reopening any date you fix up for the otherwise I would be wasting your lordship's time.
How many minutes we have?
14 matters, okay.
1/4.
Yes, sir.
So your lordship.
17, there is only one matter.
One matter. On 17, you can have this matter, Mr. Patil.
Grateful, sir.
Just show the appearance. Yeah.
So my appearance for open number 6 may I will obtain.
Yes, OP6. Yes. Oh.
Item 56. Item 56.
Yeah. The matter has come.
My lord. My lord, my case will be listed for today for releasing arrear salary.
Petitioner has explained so. Arrears of salary.
My lord.
Your 14%. We shall send the intimation to the registry of this court in this regard within 1 week. Petitioner is expected to conduct himself respectful and create no ruckus in the office. Whether things are going on well there after this order. Mr. Behra,
My lord.
there is order dated 20 August
lord, my lord.
2025.
He has to comply, my lords. That order is for the compliance.
Directed report for duty in the office of district education
My lord.
officer
My
Gajapati.
lord. Because he was not joining, the order was like that.
Now, as the petitioner reports for duty as directed, his duty report shall be accepted by the DEO.
My lord.
Has he reported for duty?
My lords,
Yes, sir. I reported for my duty, my lord.
my lords, we have not filed counter.
You want to file counter? Now you have reported for duty, na?
My lord, I am reporting myself for duty before the DO open number 4, my lord. I may be given a one chance for a presentation, my lord.
Presentation will give you on the next date.
Nice, sir. My lord, as per letter dated 14/5/2018, the Commissioner cum Secretary under Annexure 51, please see, my lord. There is no scope, no power, no locus standi to the BO or the headmaster of held up my salary, my lord.
November 2025. All right. First week of November 25. Okay. Next.
Sorry to disturb your lordship. He has some difficulties on
I
that
have
day.
no salary till date, my lord.
Yeah, whichever date.
23rd. 23rd.
Take that. Whichever date.
Yes, he does.
27th to 28th.
All right. No, whichever date you say, we'll get it.
28th.
Yes,
28th.
Yes.
My lord, please see.
All right. Next.
Item 57.
57.
Item 57.
The students matter will not, you not kind enough to call for the answer sheet.
Answer sheet. Your case that the university did not in the college.
Not the student, but
What they have
said that declared, but that date they have given is wrong.
opened them, sir. Just open them. After all, there is nothing. Any cobra is kept inside.
No, usually it's presented in a sealed cover. So yes.
Pursuant to order dated 18/9/2025, learned senior panel counsel Mr. Pattanai very graciously has produced the answer sheets of the petitioners. Sealed covers are opened. See what is there.
Your lordship wanted to see that
Whether valuation is not asked.
Petitioners are 9 in numbers.
Let you see this instead of me. See whether valuation is done or whether it is right wrong is another thing.
Yes,
just see. Any question is left unvalued. Then we will have right of valuation.
My mistake on the envelope, it has been mentioned 8, but actually 9.
9.
Your Lordship may permit.
9 answer sheets are produced.
Your Lordship may permit.
Just rectify it. Don't dwell into the merit. Just to see whether they are reading.
Most of the answers, I guess, answer 0, 0.
That we can't help. 0 is invented by Indians only.
That's true.
For Aryabhata, for Bhaskar, Aryabhata.
Aryabhata.
All are values.
Valued 0.
Valuation can be result into 0 also, sometimes minus, if rules provide. Let us see your question. Let us see your question and see your answer. You are finding with 0.
Yes.
Which is that subject?
Physics.
Physics. Do you have a rough idea of physics, elementary physics?
Yes.
Just read the question. Let us see how we will answer them. What is the question?
Question and then.
Just reading that. Which students of which standard?
First semester.
First semester PG.
You are from science background? Yes.
Science background, but I am the physics honors.
Physics.
But not in PG.
What is work? What is work? Define work in physics. How work is defined in physics?
56.
Very small question I am putting to you. I have many other questions. But a very small question I am putting. Since you claimed that you have basic knowledge of physics, I am asking you. Then you cannot say whether the answer is right or wrong. Work is defined as force into distance in physics. Work is equal to force in de Broglie's principle. Work is equivalent to force into distance. Okay. Anyway, then you cannot value them. Just give it to me. I will look into whether they're right or wrong. I have elementary exposure to science, though not in a higher level, but the elementary things I know. Anybody from science background in the court hall?
No.
From physics?
I learned
physics domain?
Chemistry.
Chemistry.
My learning. I learned from chemistry side.
Do I have a physics subject? No, there are chemistry papers also. I will distribute them to you now. Yes. Which is your domain?
Also humanities.
Humanities.
English. And PG in English and honors in English. Literature. So that all sounds like Greek and Latin to me.
These do not appear to be Wrong. Answers are rightly assessed by the. These are the things which I was taught by my teacher. I'm just reminding his face now, though he is no more. Perhaps this candidate does not know what is meant by coefficient at all. He does not have that idea at all, absolutely. Therefore, rightly 4 mark, 0 mark, like that they have given 2 marks. I don't think that the first candidate has any case. Absolutely no case. No. This is out. Each question carries how many marks?
That particular.
You have to keep one teacher here when you are arguing matters of education. Otherwise, again and again, we have to adjourn the matter. He has awarded 8 marks. Out of what, I do not know. Is it out of 10 or out of 15 or 20? I do not know. Answer appears to be very attractive. Answer appears to be. Heisenberg principle here discussed appears to be very attractive. Keep on all physics. All papers are from physics. Keep one teacher, one lecturer from your university, preferably having some 10 years experience, something like that, so that we can sit here and he can tell us whether it is right or not. All right? And don't disclose name of professor till he comes here to anybody. His name should not be disclosed to anyone till he comes before the court. Okay, let him do the exercise. I have done my rough estimation of 1-2 papers. Very long back, I studied physics. But I remember Heisenberg principles, Feynman principles, de Broglie's principles, Einstein C is equal to MC square. These things I remember, very shortly I remember. But it is not up to that level. It's a lower level. Let that professor come so that I can have interaction with him. On which day you will keep them?
Anytime after vacation. After vacation. Let it be third week or fourth week.
The sealed covers were open and 9 answer sheets were discovered. This dash covered. First of all the answer sheets were given to the hands of learned counsel appearing for the petitioner and his colleagues as well. First, they have made a cursory reading of the same, but they are not in a position to say on the valuation of the answers given by the petitioner. First, court also turned the pages of 2 answer sheets. First, after doing this exercise, the senior panel counsel appearing for the petitioner is requested to keep one a lecturer in physics. On which date you will keep him in present? Just to satisfy ourselves.
Anytime,
because we cannot send the students back saying that no, we can't see anything. We have seen we have enormous power. Just we want to assert what is done. They should also have satisfaction.
Manish may make it assistant professor
Assistant.
or associate professor.
Correct. Because lecturer post is not there. One assistant professor
of the university
in physics. Department of Physics
of the university.
Present before the court. To keep him present before the court on which date you will choose. It will take some time.
Yes, it will
take some time
because availability of
availability of on 17 we will have 17 we have few matters. On 10 we will have. Okay.
Yes, sir.
Okay.
17.
17. 17.
Not this. The papers will be retained by the
the unsealed covers along with all the answer sheets are handed back in the same form to the panel counsel for the university with a request to bring them back on the next date of hearing. Yes, next.
Item 58.
Yeah.
This is another case of a student, my lord, of the CBSE. This was 2.
Again, your lordship had called for
They called. But here, my lord, after getting the counter of my learned, I have got that there is a procedure for revolution. There is a
submitted before your lordship on the last occasion also. There's a 3-tier system.
Yes.
Where the first, if the candidate is agreed, he can call for the Xerox copies. Thereafter, if not satisfied, can go for verification of marks. And thirdly, not satisfied, he can apply for revaluation also.
That is there.
Here in the case, all the 3 steps have been.
Yes, I'm saying. There I'm saying. What he has stated in his counter, I have not seen the papers, my lord. What he says, the students have requested them for revaluation. Suppose, let us take the mathematics only for 2 questions. But after he got the photocopies of his own answer script, he found there are many other questions which has not been properly valued.
Properly or which have not been valued yet?
Valued, but not properly. That is why I am saying.
Therefore, revaluation.
What I say, since there is a scope and I have not made all the questions at the first instance, I have lost there. Only for the future of the student. Now he has been selected and get a rank in the admission for this engineering examinations. So what I only submit, my lord, in paragraph 9 of my petition, I have stated the question numbers. If my lord will allow them to, I am not saying I will be revalued. Any authority of their teacher of their choice, let them be revalued as per this question only, he will be satisfied. This was my lord, this is innocuous prayer.
To that, I would like to place before your lordship that those questions which he is raising were never applied for by the candidate.
Yes, I am saying.
But however, the circular, your lordship may kindly come to my counter at page 16.
What it says?
It says that.
But there is a provision for revaluation.
Yes, provision for revaluation.
And you revalue them.
Only that much, man.
That's all.
This is my innocuous.
Only those answers which he has been raising.
Para 9.
No.
Para 9 of the writ petition, I have stated.
Is it revaluation is answer based, answer specific, or whole of the paper?
No,
how it is done?
The candidate under the circular, the candidate has to apply where he is agreed. Any question.
The question number.
Here is the case where
he has to give the question number.
Yes. I have given 2. Now I found that there is more. So only I request my lord, also to my learned friend, to send it to some
revalue them and send the result to revaluation result to the petition.
I will wait him.
That's all.
In that case, I'll have to take instruction because this process is over. And it's
now any
the question
teacher
is,
of your choice.
that those particular fractions which has to be revalued, whether that can be done with after the process.
After the process means he applied even before the correct date only.
No, that those
In
things
time he has applied.
he has
He
applied
has
and
paid the fees also.
those have been valued. No,
They have been valued already. Revaluation is done.
revaluation has been done to the questions which he applied for.
Applied for.
Now
he
verification of the answer kit he has received, my lord, from their authorities, photocopies. So he found that there are other questions which requires a relook. That is only my request, ma'am.
Revaluation of
Not revalued answers.
valuation.
Only those I could not have applied.
Questions, the answers which you had not tendered for revaluation.
Yes, madam.
So you want to have them revalued.
Relook to that matter. Only that
What
matter.
was the last date for applying for revaluation? When did you apply? What was the last date?
That was on 27/6/25. I have written somewhere.
27/6?
25.
25. You applied on which date?
On that particular date.
Where is that? Show your application.
That application I didn't have. I have not filed.
Then you have to show that.
No, they're admitting, my lord. It is not in dispute.
No.
Only my difficulty.
Since you are
Yes, that was
tripartite system.
Yes.
It's between you. By agreeing, you cannot pull down the court building.
no.
So it is also interested. We should be heard before our building is pulled down. That way,
Yes.
you have to give us the date on which you had applied. Which was the last date for application? When he applied. If this prima facie, if you establish, I will direct them to undertake revaluation.
My lord.
In the meantime, what
Yes.
I was trying to place before
This is-
that circular says that which has been valued, meaning revalued, cannot.
I am not.
No question of re-evaluation.
Yes.
That is-
But whatever is valued,
Madam.
that can be subjected to one re-evaluation. What Das says is, after seeing my paper, I had applied for re-evaluation. I'm asking on which date you applied. Where is that application?
Application I have not given the answer I have given. Page 16.
No,
mechanism.
that makes no sense.
The
I'm
date
asking you
in
on
the-
which date. On which I am very specific in
Yes,
question.
I
Unless
understand.
they are
I understand,
answered,
my lord.
I will not be satisfied.
Yes, ma'am. That is. This is they have written. Just I'm reading out because that is not there. It will have answer. It will have answer. It may. They say that your reference to your online application number so and so for evaluation of mark of class 12-25 men, and this is the answer.
Yeah,
27/6.
No, for other answers.
Other answers I have
When
not.
did you apply for
No,
revaluation?
other question I could not, my lord, because that is the last date. That is before I pray before my lord only. That prayer I am now making, my lord. I have only suppose 2 questions I have asked them. Please revalidate it.
They have done that.
They have done that. I am not finding fault with them. What I am saying, my lord, after getting those photocopies, I have given the answer script also.
When did you get the photocopy?
Photocopies I have given it. That is, I have received on Annexure 5, my lord. That is on. The date is 27/8, I think. It's invisible 27/8, August I have received. All these paper I have filed. So what I found it that there is some.
When did you apply for?
I have applied for.
When did you apply for? When they were supplied? When did you apply for copies of the answer sheets? When you were supplied with them? When did you apply for evaluation? These are the 3 dates because I got this in mind.
No. The date, my lord, sorry, my lord. I have not.
There's a date line.
Deadline is there.
That give that.
I have not.
Applied. No, this is a prescription.
My lord.
I'm asking facts.
Yes.
This is your notification that you can apply for this one.
Within that date.
Within that date, you can do 500 rupees per subject
My lord.
for scan copy.
And second is verification. Third is
verification, revaluation, both for verification and revaluation. The date applying online is 7/6/2025 to 10/6/2025. Therefore, I want to know on which date you applied.
That I have not given, my lord, but I have got this answer script. You probably maybe mistake on my part. I didn't put that question to
just ascertain that. You just ascertain from your client when you applied, you bring that material.
Yes.
You share a copy of this with Mr.
Because they've given the answer scripts, the photocopy. So I thought it is there. Only my innocuous prayer is this much.
No, it's not innocuous. Now, if I allow this, other students will come. They will say, you have allowed after the cutoff date. Why not us?
But the fact remains, my lord.
Fact remains. Question is
no, I will give that. I will give it. Can be tomorrow, my lord. Just today evening I will get it. Tomorrow only.
Tomorrow?
Yes, I can give it. This is the only factual aspect.
Now he is studying now. Students are studying.
Examination is over.
Examination is over.
No, here he could not take the admission because of this result. He did have the percentage, that required percentage. If I will get some mark, then he will get the percentage.
But tomorrow, brother, now the dates of admissions are also over, perhaps.
No, they have up to 30th September. They have extended this OJE. Yes, Orissa JE. They have extended.
Call tomorrow. Let us take a check.
Only I will give that date.
Petitioner's counsel to furnish the date on which his clients had applied for copies of the answer sheets, comma, the dates on which the answer sheets were supplied, and also the dates on which revaluation was applied for. Okay.
Item 59?
59? Tomorrow, my lord. Tomorrow.
My lord, others will be.
No, you retain those. You don't want to.
Now this is not required. As per my prayer,
let us see.
Yesterday, my colleague appeared. Maybe taken off some of the day after vacation.
Vacation. In the first week of November, can we take this?
Yes, madam.
First week. Any entry order is there? Entry order to continue following second week of November. Okay.
Question 60?
Item 60, my lord. Yes, Mr.
Last of the directed me to obtain the instruction ballot. The first the application for the legal air ballot applied on
anything has been done by the concerned officer.
I have officially requested them to that has been rejected in the year 2003 ballot.
2003 itself.
Ballot for CBS ballot. That is online application and online it is communicated ballot. Presently ballot here the present Tahsildar requested the petitioner to apply afresh.
You apply afresh and they will give.
We have applied on 24/3/2023.
They themselves applied.
They didn't take any initiative according to that. 24/3/2023 we have applied. Then the poor person.
Yes, 24/3/2023 applied.
They applied that is rejected on 6/5/2023.
But there was no such information.
Information online application, it is communicated online ballot.
But he is a poor rustic person. He does not have any.
What to do? Rules are like that.
Lordship, he
You
was.
file appeal against that. You furnish copy of the order at least.
But presently, my lord, we have did one thing, my lord, lordship complied with your lordship's order, my lord. We have shown to have applied, my lord, and that is, my lord. He is the adopted son, my lord, and the deceased having one daughter, my lord. He belongs to another Tahsil, my lord.
This is the trend.
And that the information is required, my lord. For that reason, we want some more time to issue the legal aid certificate, my lord.
Where is the application made by the petitioner?
Petitioner made
18/9/24 furnished details of so.
Present well, the RI also inquired in the second page, madam.
24/3/23 she applied for. And 28/2/2023 there is an order. What is this order? 30. No, where is their application? Where is the consideration of their application?
That is not available in the site ballot.
How?
That is not.
How, brother? How it is not? It's an online application, na?
Online application.
You have made online application.
Yes, my lord, on online application.
Online ballot.
Look into Intel properly. On 24/3/2023, she has applied for. What happened to that application? Where is the order?
Yes, this is an online application.
They have only available in the site ballot that has been rejected on 6/5/2023.
6/5/23.
My lord.
Where is that order?
It is
Order is not there, my lord.
Then what is that? That's the intimation you have got now.
That intimation in itself in the
On 6/5/23 that has been rejected.
my lord.
But how they will know? It should be, it is online result only.
Online they have to on their application number they have to verify on the where they applied for. And from there they have get
There is a
reference
common
number.
portal. There is a common portal base. It
They
is
are
everything.
loaded to that and there they have to download all those things.
That is there, my lord.
Yes, they have rejected your application on in May 2023.
But lordship, as per the client instruction, he said that he has searched on the portal, but there was no result showing on the portal. So he was
At
not.
least give that copy of the order. You give one copy of the order so that
Solve the instruction.
This is-
I have solved the instruction, my lord. Pursuant to my lord direction, we have already applied, my lord. He did not
Reconsider.
pursuant to my lord's direction, we have already applied and steps have been taken to
Issue.
for issuance of the legal aid certificate.
you are issuing a legal aid certificate.
No, but time stipulation is there, proclamation is there, my lord.
There is a procedure for
My
that.
lord, procedure, one thing, my lord, they have suppressed. One daughter of the deceased there. He is the son of the daughter is adopted by the.
That is what villagers told.
My lord.
That Mahajar, I read that.
Yes, my lord. That another tahsil that has to be requisitioned. That has requisitioned already, my lord.
It
So that report has to come. So only, my lord, more time is required to provide the certificates.
Learned ASC has produced certain documents in compliance with the order of this court dated
12/9/2025.
12/9/2025 and submits that the fresh process for consideration of the prayer for issuance of the legal aid certificate is initiated and the same shall be accomplished if a reasonable time is granted. First up, call this matter on 24/10/2025 for accomplishing the task. First up. On that day, you have to bring the order, this side or that side. We don't say issue, not issue, we do not know. Okay?
Yes, ma'am.
On the said date, the order passed on petitioner's online application dated 24/3/2023 should be.
That has been rejected. We have a
fresh dating on that day.
We have applied so much, my lord.
Okay. On that day, the outcome of the process should be placed on record.
Yes, ma'am.
Whichever way. Okay. We will not say, "Oh, Lord, we do not know whether to grant or not to grant."
That's true.
Call on 24. No, instead of 24, make it 30/10. 30. So that they will have reasonable time. Next. Over. Weekly list. Any urgent matters you have got? Not anybody.
3, my lord.
Urgent. Is it urgent? If it is not urgent, give me so that we will have it this one. Don't project fictitious urgency. If real urgency, tell us.
After death of his parents, my lord, she is alone, my lord. She is alone, my lord. She is depending other, my lord.
What is the matter?
No, matter is after death of his father, my lord, she is applied for rehabilitation assistance scheme, my lord. The application has been rejected on the ground there. A delay of 2 years, my lord.
Delay of 2 years.
2 years, my lord.
Was it during COVID, etc.?
My lord, my lord. No, my lord, COVID, no, my lord.
Post-COVID.
Post-COVID, my lord.
Post-COVID.
My lord,
any provision for condonation of delay under the amended rule?
This, my lord, this is the rule, my lord. My lord.
Majority, major the 2 years.
2 years is how you reckon that 2 years?
My lord, she has applied legal certificate, my lord. She has applied a legal air certificate, my lord, on very 2011, my lord. Other once Ranjani Naik, my lord, he has objection on the legal air. He is claiming he is the one.
Mr. Mohanty, who appears in this matter?
Mr. G is there, but
only problem after death of his father, he is alone, my lord. He is the only lady, my lord.
No, there is a now clarification has been issued in the light of
dispose of Airship, my lord.
Can it be tomorrow?
Tomorrow.
Bring it in.
My lord, item 16, my lord, weekly list, my lord.
Urgency.
My lord.
What is
my lord, school is running. The students, those are prosecuting the study, they are deprived from getting from MD all allied benefits.
Means
and that school is running without recognition. The state government held the recognition, but the government, the appellate authority, honorable minister, allowed the school and allowed the restored the recognition, but the authority, the administrative authority, they have kept in the file without issuing the order of the honorable minister.
In terms of the minutes of the minister.
Yes, ma'am. Order, ma'am, appellate authority, minister is the appellate authority in the appellate court, pass the order to providing the recognition.
The appellate authority.
My lord.
Is minister appellate?
Yes, my lord. Yes, my lord.
Under which rule?
My lord, we acted.
When a minister takes a decision, he is head of the ministry, department. That's what which is that famous judgment of Apex Court. A minister is a
appellate authority, my lord, 6B, provision 6B of the 5.
Minister has been decided the appellate, like SICA Act, my lord, so that BIFR and AFR, SICA. They are minister. Now this has been repeated. In SICA Act, minister is the person who can hear this.
131.
Some other provisions are there where minister has been authorized. None else other than the minister. Other than secretary. In SICA Act, it is minister. 25O. Sick industrial.
And the hearing, order of the ministry to binding it is final, man.
Which is that read.
My lord, page 131, provision 6B. My lord, subsection 5, any educational institution agreed by an order of the committee withdrawing or suspending the recognition of any educational institution may prefer an appeal within a period of 30 days of the receipt of the order before the state government, whose decision thereon shall be final.
State government.
My lord.
Whether minister is part of the government.
My lord, ministry is the state government. Government is the ministry, education is the government.
There is a judgment of, there is my judgment. Take out Sudhindra Rao versus State of Karnataka, affirmed by the Supreme Court. There, the petitioner had given a resignation letter to Chief Minister. The rule said it should be given to the President, to the government. argument was Chief Minister is not government, Secretary is the government. I rejected it, saying that Minister is a part of government, and therefore application to Minister is application to the government. That came to be upheld by the Sudhindra Rao versus State of Karnataka. Yeah. AAR, write down. You are only reading sections without reading other rulings and other things. All substandard argument. AAR 2020, AR online 2020, Karnataka 1433. Okay. Bring that judgment.
My lord.
It is in your favor.
My lord.
Just reading one section will not help you. This is from my go to SLP, that one. Sudhindra Rao versus Science. Just look into it and bring it.
My lord.
Next date, we'll have this matter on 27. On 27. In the meanwhile, bring that judgment.
My lord.
All right. Next. Some research should be done always. Make notes. They should be very handy. Within minutes, you should be able to lay your hands on the rulings. Then it becomes profession. Otherwise, turning the pages when judge asks questions, not answering at all, standing like a mute spectator. How that's going to help you? You should be always, this is the Saraswata Loka. Advocacy is Saraswata Loka. Continuous study, continuous contemplation, reading, storing it in a packed material in such a way. Because suppose you have got a huge go down, everything is there, but you don't know which item is where. What is use? Therefore, you should also see how to remember. Pranayama you should do. Dhyana you should do. Meditation you should do. Osho says that. When you do all that, your memory sharpens. Making Surya Namaskar, making yoga, then your memory level goes up. Number one. Number two, how to remember things. Number two, when somebody says, I remember, not that. How to recall the things remembered. There are such techniques in Hindu philosophy. There are such books. Just read them. How to remember, how to reproduce. How to remember itself is an art. Remembering is an art. With name, with the smell, with the letter. For example, your Duryodhana Sahu. Just immediately, an example I am giving you. That name is very rare in other parts of the country. Then Duryodhana is also named. It's a factor for remembering. Duryodhana takes us to Mahabharata. Okay. Then Mahabharata takes us to Vyasa. Like this, one by one. That way, the art of remembering. Then art of reproducing. All that should be learned by the lawyers. I've seen certain lawyers in G. Ramaswamy. What a memory, what a reproduction. Parasaran, these two persons, Sorabji, when they were arguing, and even the other persons I have seen, Anil Diwan, who argued that DS Nakara. What an argument. That way you should have developed. Even notes should be with you. Even notes should be. Lifelong notes is one thing. For case you should have the notes. What is the latest first decision? How law has developed. Latest decision of Orissa High Court, the neighboring High Court, Calcutta High Court, the Kerala High Court, Madras High Court, Bombay High Court. How they have treated the subject. This comparative analysis has to be done. That helps you. That will give you the strength to argue everything. That is how the things are.
Date is 27th.
On 27th, can you have this matter?
26th.
26th.
Right.
26 is Sunday. Anyway, I will sit that day.
This month.
This month, impossible.
Impossible for you to come in
Because my
for me, yes.
students are not getting any benefit. They are not also getting the MDM man.
Let us. All right, I'll make this over. Thank you.